Good morning and welcome to the 21st meeting in 2020 of the Finance and Constitution Committee. Can I give apologies for both Alec Rowley and George Adam for this morning's meeting. The first item on our agenda this morning is to decide whether to take consideration of a draft report on the UK Internal Market Bill, LCM, whether that should be taken in private at future meetings. Can I ask, are members agreed? I see no disagreement, so that is agreed. Thank you. The next item on our agenda is to take evidence on the UK internal market from Professor Michael Dugan, who is Professor of European Law and the Jean Monnet Chair of EU Law at University of Liverpool, and Dr. Emma Lygate, who is a Senior Lecturer at the Sussex Law School. I welcome both of our witnesses to the meeting warmly this morning. Can I remind members that when they direct their questions to a named witness, please, that Professor Dugan or Dr. Lygate, and if either witnesses wants to add something to the other's response, then can you please request to speak using the chat function. But we'll now go straight to questions from the committee. And if I may start, the Public Administration and Constitutional Affairs Committee at Westminster have said that the proposals in the Internal Market White Paper to set in law the principles of mutual recognition and non-discrimination will effectively create new reservations in areas of devolved competence. And Professor Dugan, in your written submission, you state that while on paper the evolution might continue to look the same and might even look more extensive, in practice the operation of the UK internal market has real potential to limit the capacity of devolved institutions to pursue different economic or social choices from those made in London. Can I ask both witnesses to explain why these, at the same time, devolution can appear to look simultaneously more extensive and more constrained, and what is the reality? And Professor Dugan, could I ask you to respond to that first, please?
Thank you. Can you hear me okay?
Hear you fine, Michael. Thank you.
Thanks very much, and thank you very much for the invitation to participate. I think it's helpful to explain the distinction between on paper and in practice by pointing out that this is really how many internal market rules operate. It's true most certainly in the EU context, which is the internal market that obviously we're most familiar with. So on paper, the devolution competences don't particularly change as a result of this internal market bill. Obviously, there is a new addition to the list of reserved competences. The Act itself will be added to the list of provisions which can't be modified by the devolved parliaments, but the other devolved competences themselves look like they're going to remain the same. And in addition, of course, the UK government has repeatedly promised that after the transition period ends and the full effects of Brexit become clear, that there will be an increase in competence for the devolved institutions because many of the issues which might previously have been subject to regulatory intervention by the EU would now become more fully subject to the competence of the devolved institutions. But in practice, of course, the way that internal market principles operate is to impose restrictions and limitations on competence exercises, and that's universal. All internal markets work by establishing a set of horizontal principles that seek to at least influence, but in most cases restrain and restrict the way that competences are exercised in practice. And that's definitely true of this UK internal market bill by imposing quite widespread obligations of non-discrimination, but more importantly, mutual recognition. The UK internal market bill is seeking to restrict the way that devolved competences operate in practice. I think it's fair to say that there are two main factors which are particularly striking under the UK internal market bill. The first is that it's effectively a sort of Cassis de Dijon on steroids. It takes the idea of mutual recognition and it multiplies it and magnifies it. And makes it a far stronger principle of mutual recognition, for example, than EU lawyers would recognise within the context of the single market. And secondly, of course, it doesn't acknowledge the simple empirical fact that the UK internal market is completely unique in the world because of the size of the English economy and population relative to the size of the other participating territories. And that simply means that a principle like mutual recognition that might operate in a relatively neutral manner in the context of a large organization like the EU will not operate in a relatively neutral manner in the context of a relatively small number of territories like the UK, where one territory is not just relatively dominant, but absolutely dominant over the others. So I think when you put those two factors together, the Cassis de Dijon on steroids and the simple, inescapable empirical fact of the size of the English economy and population, it means that principles like mutual recognition will have an impact in practice upon devolved competences that makes a real distinction between what exists on paper and what might actually happen in practice.
Dr. Lightgate, do you want to add anything to that? Thank you, Michael Dugan.
Sure. I mean, I think in terms of new reservations of powers, there are specific concerns that arise with respect to subsidies in the provision of public funds. I think with respect to your question about the seemingly sort of paradoxical nature of this in terms of both giving and taking powers, I could probably best illustrate that using an example regarding the free movement of goods. So, and looking at new sort of post-Brexit secondary legislation in this area. And as Professor Dugan said, the basic approach of the EU is that where harmonization is necessary to achieve free movement, product regulation is harmonized, and that's managed at the EU level. In the absence of that, a lot of this post-Brexit legislation actually devolves powers that were previously harmonized. So if we take the example of maximum residue levels for pesticides or new GMO authorizations, these are issues that were managed at the EU level and were harmonized and are now devolved in secondary legislation. So this seems to give greater powers for devolved administrations. But perversely, I think you could say in practice, it might do just the opposite. So, and that's because of, again, as Professor Dugan said, the asymmetry in the size and market power of the devolved nations. So, for example, England might authorize a new active substance for pesticides or a new GMO, and then would be able to export these products freely to devolved nations, even if they had controls domestically. And in so doing, they could competitively undercut these producers and effectively undermine permitted divergence.
Thank you, both. Of course, the Scottish Government's view is that the UK internal market proposals are completely unnecessary, as common frameworks provide arrangements to manage the intersection of EU law and devolved competence in areas of policy and regulation relevant to the UK internal trade. Can I ask both witnesses whether you agree with that view? And Dr. Lightgate, would you like to respond to that first?
Sure. I mean, I think the core of any approach to an internal market that is as integrated as the UK's has got to be harmonized rules that have some sort of a strong joint consultative process underlying them. Obviously, they can't be set by one of the countries. And the EU provides quite a formalized approach to this, which involves EU bodies, the Council, the Commission, the Parliament setting regulations that apply to all member states. And the UK, of course, is trying to replicate this with a sort of non-statutory process of setting out common frameworks. And if these frameworks are agreed, it will dramatically reduce the scope of the market access principles. So I think that there are a lot of questions that I have about how this common frameworks process sits within the internal market bill, because you have a statutory legislative basis for the market access principles and not for the common framework. So I think there's probably a role for both, because that's the kind of decision making that there is a balance between, of course, harmonization and devolution, and that might involve hard choices in terms of erecting new market access barriers or allowing products that wouldn't be the regulatory choice of one nation for the good of free trade. But to my mind, this, as in the EU, should be a process that happens around the margins of a broadly harmonized framework. And I would raise specific concerns about how legislation might undercut common frameworks both with respect to trade agreements, trade negotiations, and also with this. I think the Scottish Continuity Bill raises some issues in this respect, but perhaps we'll come on to that later.
Okay, Professor Dugan.
Thanks. I certainly wouldn't describe it as completely unnecessary. In my written submission to the committee, I mentioned sort of why this historically hasn't been much of an issue for the UK. When the UK first joined the EU and began participating in the EU internal market, there was no devolution. So it wasn't really an issue pre-EU membership. Devolution happened within the context of EU membership, and the EU internal market rules effectively provided a framework to regulate not just the EU single market, but also, in many respects, internal trade within the UK itself. And so really this problem is a direct consequence of Brexit, because what we will have is a UK which is based on devolved settlements in Scotland, Wales and Northern Ireland, but which takes away the EU framework, which has previously helped to regulate trade relations, not just within the EU, but also within the UK itself. So the problem is very genuine. And in fact, the main issue, I suppose, is less, the common frameworks that are currently being discussed or negotiated. It's more about how the economy and society evolves into the future, because in many cases, in the EU context, for example, every time that a member state changes its product requirements, every time that any member state introduces new restrictions on, for example, alcohol consumption or cigarette consumption, every time new scientific developments occur or changes in technology or consumer preferences, every time that a regulatory regime changes in any member state, it automatically creates trade implications for all of the other member states who want to do business with that country. And so I think it's useful to bear in mind that internal markets are not static things. You don't just establish a set of common frameworks and then leave them there for time immemorial. Internal markets are about constantly managing developments in local and national regulation and the impacts that they have upon trade relations with the other territories that you're working with. So it's a genuine problem and it needs some sort of solution. I think it's fair to say this is not the solution I would have picked if I had a free hand in designing it. But I think the problem itself is genuine. I think that my complaints about this bill are not about the fact that there is a problem that genuinely needs some sort of solution to address it. I think my problem with this bill is that the solution is not necessarily a very desirable one within the context of the particular situation of the UK.
Thank you, Professor. I'm now going to go to Murdo Fraser. Thank you.
Thank you, Convener. Good morning to our witnesses. I wonder if I could just follow up the line of questioning from the convener. Maybe start with yourself, Professor Dugan, looking at the question of the impact on devolved powers from provisions of this bill and some of the concerns you've expressed about how the ability of devolved administration to act might be constrained by this. And I'm wondering if you can say a little bit about how you think the bill might therefore be amended to try and address this concern. And would, for example, the introduction of a provision around proportionality be part of the solution?
I think if I were seeking to amend the bill, taking its fundamentals as a given, I think my amendments would go much further than just tinkering with the bill, I have to say. But if we're going to take the fundamentals of the bill as they are, the idea that we're going to have some system of mutual recognition and non-discrimination, which applies across broad sectors of the economy and goods and services, if we're trying to think about how to make that a more attractive proposition from the point of view particularly of Scotland and Wales, I think the first thing I would do is drastically expand the system of potential justifications and derogations from the principles of mutual recognition in particular. In the EU context, mutual recognition in the absence of harmonisation is only a presumption. And a member state can rebut the presumption of mutual recognition because it has higher or better standards than its peers on any legitimate public interest ground. The main ones are usually public health, environmental protection, and the protection of consumers. But there are a potentially infinite number of public interest grounds on which mutual recognition can be derogated from under EU law. It can include protection of workers, protection of particularly vulnerable children, protection of the reputation of your national institutions. So there are a huge variety of grounds. So that's the first thing that I would do, is actually significantly broaden out the range of legitimate public interests that are capable of rebutting a presumption of mutual recognition. The second thing I'd probably do, is particularly from the point of view of Scotland, is argue for a principle of functional equivalence. In other words, that as long as standards are basically the same as each other, they're not particularly high or appreciably lower, they should be treated as functionally equivalent. So that mere technical differences, just effectively simple differences in the way that particular requirements are phrased or have to be met, do not become barriers to trade in themselves. This will be a familiar principle in the EU context, but we don't see it present in this internal market bill. So wider justifications, a principle of functional equivalence. And thirdly, this is probably more difficult to achieve other than by me describing it fairly loosely. I think it's probably to be taken for granted that Scotland isn't looking to lower existing standards significantly below those which exist at the moment. Some of the fears which have been expressed are that Westminster, in due course, might well go down regulatory divergence from existing standards in a way that Scotland feels less comfortable with. And in that case, what I'd probably argue with is a right to, in effect, free movement for Scottish, Welsh and Northern Irish goods within England based on compliance with existing minimum standards. So that, in effect, there's free access for Scotland and Wales to the English market as long as they meet the minimum standards which have been agreed by everybody. Now, that's obviously a much broader proposition because it does require processes of legislative dialogue and if not harmonisation, then at least an understanding about what the minimum standards should be. But in effect, what I don't think Scotland wants to see happen is that Scottish goods or services are excluded from the English market because the English market has decided to go down a technically different route, but actually the Scottish standards remain higher in substance. I think that would probably be an undesirable outcome for Scotland.
Okay, thank you. Maybe I could ask Emily Lydgate the same question.
I think that was a very complete answer. I would underscore Professor Dugan's points. I would just add one additional thing in terms of sort of amendments to this particular bill, which is around the scope of delegated powers. Because in this formulation, the Secretary of State can change a number of things by secondary legislation, including what types of regulations are covered by the non-discrimination principle, the list of exemptions from findings of indirect discrimination, and the overall Schedule 1 exemptions from market access principles. And this seems to consolidate quite a lot of power into on the UK level.
Okay, thank you both. Thank you, Convener.
Thank you very much, Murdo. Angela Constance, please.
And good morning to the panel. I have separate questions for both our witnesses, but you'll no doubt, Convener, keep me right about time. But if I could start by asking Professor Dugan. Professor Dugan, you said in your paper that the problem isn't Scotland's or Wales wanting to do things differently. It's actually the risk of magnifying the economic and constitutional dominance of England. Therefore, I wonder if you can say how this bill in practice will limit the opportunities for devolved administrations to, one, actually enforce their own laws, and two, limit their capacity to pursue different economic and social choices.
I think what I'll do is maybe answer your question in two stages. First of all, by highlighting a fairly straightforward practical example that I think illustrates the potential risks very clearly, and then maybe drawing out some of the key lessons which we see in that example. The example which I gave in my written submission was if authorities were minded to introduce a ban on single-use plastics. To be frank, it could be almost any measure to protect the environment or consumers, but the example I've given is the introduction of a ban on single-use plastics. When you work that measure through the scheme of the bill, the answer is that the Scottish authorities can introduce that ban and enforce it against Scottish producers, but they can't enforce it against imported goods from England or Wales. Now, in the reality of the the UK market, the simple fact is that England is 85% of the population and the economy, and has a huge manufacturing base. If you can only enforce a rule like that against your domestic producers, and you can't enforce that rule against imports from England, you may as well not have the rule at all, because in practice you have no means of actually stopping non-recyclable plastic from flooding your market and being freely available for sale. And all you're doing is imposing an extra compliance cost upon your own producers that they still have to satisfy, that puts them at a competitive disadvantage. So in a way, that the operation of the bill with an example like that is to say that Scottish producers are disadvantaged, and we can't actually deliver on the public interest objective that the regulation was intended to achieve. I think if we take an example like that, what we really learn from this bill is that it's not just the detailed principles in a way which are potentially problematic. In a way that the bill's underlying assumptions strike a balance between trade and local democracy or local autonomy, which I think many of us who are discussing this bill at the moment among academic circles find quite problematic. The starting assumption of the bill seems to be that regulatory divergence by Scotland and Wales is a problem, and it's a problem that needs to be managed. It's not an expression of local democracy. It's not a valid search for different solutions to your own societal problems. It's a problem that needs to be managed. And I think that whole starting assumption runs throughout the provisions of the bill on non-discrimination, but especially on mutual recognition. And I think we also see it in another subtle way, for example, when it comes to the legal effects of the principle of mutual recognition or non-discrimination. The assumption is clearly that these principles can be directly enforced before the courts, but primarily against Scotland and Wales. The bill makes no provision, for example, to deal with the disapplication of an act of Parliament. It's simply not even appeared to enter the consideration of the drafters of the bill that it might be Westminster that creates barriers to trade for Scottish and Welsh goods. The assumption is clearly that it's Scotland and Wales who are going to create barriers to trade for English goods. So while we can talk about the problem in the details of the bill, and I think, of course, we should do that, I think it's important to recognise the underlying assumption that characterises this bill. It's the expression of divergent preferences by Scotland and Wales, which is the problem that the bill is seeking to address.
Thank you for that, Professor. So we're not even starting from an even playing field. I wondered, Professor, if you have views about whether or not the UK Internal Market Bill discourages regulatory innovation, and whether or not there is any scope in this bill for Scotland to refuse mutual recognition for the sake of broad public interest objectives. If we think, for example, the EU single market rules currently recognise public objectives alongside pure market considerations, if we think about, public health considerations.
Okay, was that question still for me, Angela?
Yes, it was.
Oh, super, thanks. Okay, on your first question, whether or not the bill discourages regulatory innovation, bearing in mind everything that I've just said, that the impact and practice of this bill on many exercises, proposed exercises of devolved competence in relation to trade in goods or trade in services would be effectively to penalise domestic producers or traders and not be able to enforce the same standards against imported goods or service providers. I think the natural consequence of that is that you're going to discourage the exercise of devolved competences if you're not going to achieve your public interest objectives anyway, and you're only going to end up penalising your own domestic producers. So what's the point of Scotland, for example, trying to ban single-use plastics if the Scottish authorities know that the ban will be totally ineffective in practice and they'll only penalise Scottish producers of packaging? The bill, it's worth pointing out, does offer a limited protection for existing restrictions or provisions that might cause barriers to trade, but it, first of all, doesn't apply to any new exercises of devolved competence to introduce novel regulatory requirements, and it doesn't apply to existing requirements if they are substantively changed, not substantially, but substantively changed. So the example I give in my written evidence, for example, would be a change in the calculation of the minimum price for alcohol. At the moment, if that rule weren't changed, it would be protected under the bill. But if Scottish authorities in the future were to decide to change the rules on minimal alcohol pricing, that would become caught by the bill and subject to its provisions. On your second question, is there any scope for refusing mutual recognition on broad public interest grounds? I think this comes back to the question that Murdo Fraser asked just before. In a way, this bill is Cassis de Dijon on steroids. What it does is it takes the idea of mutual recognition, this very strong principle that if it's good enough for the English, it should be good enough for the Scots, and they should have it too. But it strips away almost all of the public interest justifications that would be familiar under EU law. But it strips away almost all of the public interest justification, the sale of imported goods, unless they also comply with its domestic standards. So I'm just looking at my notes on in the field of goods. Pretty much the only exception for mutual recognition in the field of goods is to stop the spread of pests, diseases, or unsafe foodstuffs. So general public health interests are not a valid justification. No environmental protection, no consumer protection, no children's rights. None of those things exist. Similarly, in the field of services, when it comes to mutual recognition for authorization requirements, the only derogation is to deal with a public health emergency that poses an extraordinary threat to human health. Again, no environment, no consumers, no general health concerns, no children, no anything. So an extremely limited set of public interest justifications.
So my final question for Professor Dugan is that while there's a lot in this bill for politicians like me to complain about, you know, big sweeping powers, UK ministers, the reservation of state aid, some of the difficulties around mutual recognition that have been discussed already. And the Professor has spoke about what some potential solutions here are. I mean, is this bill beyond repair, or does the UK government really need to go back to the drawing board? Because it sounds to me like a fundamental assault on devolution as we know it.
I think it was in response again to Murdo Fraser's question that I identified maybe some of the reforms that I would think about to this particular bill if we were to try and work with what we've been given and make it better than it is at the moment. And I'd also agree, of course, with Emily's observations, for example, about the scope of delegated powers to UK ministers to change the terms of the game virtually at will. But I also hinted to Murdo Fraser that if I were sitting down to design a UK internal market, I'd probably have done it very differently. Principles such as mutual recognition, non-discrimination, I think, would certainly have a role. I think my preference would have been to have a system of pre-legislative dialogue between the 4 territories, where they sat down as equals and discussed the potential impact of regulatory changes upon trade within the UK, and sought to find the best solution for that particular situation based on a range of what I've called in my briefing paper the toolbox of trade law. You know, we have a range of principles, from harmonisation through to mutual recognition, all sorts of ways to nuance and qualify that. My solution would have been to find pre-legislative understandings about how to manage the potential trade barriers that arise from the exercise of competence across the UK. If a solution can be found that satisfies everybody, then for everyone to proceed on the basis of that solution and the exercise then of their own respective competences. But if whatever solution comes out of that process, that everyone just has to live with it. And if that means that there are barriers to trade that certain English manufacturers have to live with, they just have to put up with them. That is true in virtually every other internal market in the world. In virtually every other system, there are trade barriers, and you just have to live with them and you have to adapt yourself to them. So if I were looking at this bill again, I would keep bits of it, some of the underlying principles and tools, but I'd probably take a radically different approach to how those tools should be employed, the institutional ways in which it's done, the processes, and the legal effects.
Okay, thank you very much. Convener, do I have time to ask Dr. Lydgate a question, or do you want to go to others first?
I think I prefer to go to others first. I can come back to you, Angela, if that's okay. But maybe we should ask Dr. Lydgate just to give us an overview of your questions there anyway to Michael Dougan. Do you want to give us an overview of what you've just heard, Emily? And then I'm going to go to John Mason.
An overview of my response to all those questions?
Yes, I know there's a big. Is there anything in particular you want to add in that would be different from what Professor Dougan said?
Well, I would just make a sort of a supplementary comment that I think, in a sense, the process problems with this bill are the substantive problems. I mean, in the previous session, some of the witnesses were questioning why this bill was presented with such urgency, given that it doesn't apply to existing legislation, and legislative changes sort of in the immediate aftermath of Brexit are likely to be small. And I think I have a slightly different perspective on why the UK government might be feeling some urgency here, which is, at the end of the transition period on the 1st of January, a raft of Brexit legislation comes into force. And I think there's a broad understanding that these simply transpose EU law, but they do actually offer some dramatic changes with respect to the internal market. And I gave an example of that with respect to food safety and food standards, which is now devolved rather than harmonized. So in this context, I think even though these new powers might not be utilized, I expect the UK government wants this legislation to be in place before these statutory instruments come into force, in case the common frameworks fall apart. So I think that what we're seeing here is the UK government responding to a threat by trying to sort of centralize power over this area, or create a system that will function in case. But in a sense, that exemplifies the issues that are at play here, which is the lack of a strong consultative process to this issue.
Thank you, Emily. Can I go to John Mason, please?
Thanks very much, Convener. Maybe I can start then with Dr. Lydgate, as she was just on. Dr. Lydgate, you make the point that the United States would look at trade negotiations with the UK differently from the way the European Union would. Could you maybe just expand on that a little bit? Because I thought in the United States, for example, they have a lot of variety within America, within the different states.
So your question is about how the United States manages internal divergence as opposed to the EU?
Well, and how that will feed on to a negotiation with ourselves.
Okay, so the US does have a lot of internal divergence, and that is an issue in internal trade in the US. But in terms of its objectives for the UK negotiation, those are centralized, and in fact, they're set out in legislation. So the U.S. Congress has, in law, said what the U.S.'s negotiating objectives will be. So that means that it's not contingent on the Trump administration or the Biden administration. The objective, I mean, some of the phrasing of the objectives and the sort of strongly unilateral orientation of them is definitely a reflection of Trump, but the objectives are centralized.
Okay, and that would be different from the EU in what the EU is trying to push up standards and the US is trying to push them down?
In terms of substantive issues of what the two parties are looking for from the UK, those are definitely in contrast. But I think that the EU has essentially accepted that we'll have a fairly basic free trade agreement, which doesn't have very much in the way of regulatory alignment. So that leaves the UK with some. We don't have a demand to continue any sort of single market or quasi single market style arrangement with the EU. So it's really down to the UK to decide what kind of concessions it wants to make to achieve a trade agreement. But if it wants to achieve a trade agreement with the US, then that will imply, I think, some changes to its domestic regulation, particularly in the area of agriculture.
Okay, thanks very much. And then to switch over to Professor Dugan, I was interested in, you've already touched on the whole question of minimum pricing of alcohol, which has been quite a major issue in Scotland. And I mean, firstly, you've already kind of mentioned, I was just wondering if you could expand for me. In paragraph 15 of your paper, you talk about serious health threats, which I think is going to be the only thing that's allowed. Whereas, am I right in saying within the European Union, it has been general threats to public health have been allowed?
Yep. So I'll just double check my notes. So in the field of goods, if what we're dealing with is the principle of mutual recognition, and in my analysis, although I say that, a few other people might suggest otherwise, I think most of my colleagues would say that a change in the minimum price of a good, a mandatory minimum price for a good, is a product specification which would be governed by the principle of mutual recognition under this bill. And in that case, the only justification that would be available, for example, to the Scottish government to enforce its minimum prices against English imports of alcohol would be to prevent the spread of a pest, a disease, or an unsafe foodstuff. That clearly doesn't apply in the case of minimum alcohol pricing. And so effectively what you're left with is no potential justification whereby the Scottish government might enforce a change in the minimum price of alcohol against imported English alcoholic goods. There is no general public health justification which would allow any part of the UK to reject mutual recognition in the fields where it applies. By contrast, under EU law, general public health considerations are a valid public interest requirement. And we know that, for example, from the Scottish whisky case, where the Scottish government did rely on public health grounds in order to seek to justify its minimum alcohol pricing policy.
Right, there's quite a lot in there. I mean, could you just explain to me, I'm a layperson, but this idea of a product requirement, I mean, when I read these words, I would think, well, that means it's got to have a certain amount of water or a certain amount of something in it. But you're saying that the word product requirement could include something like the price.
So the bill gives an indicative list, and it's only indicative, an indicative list of what will be covered by mutual recognition. I should point out that I'm using the term product requirement because it's the shorthand which we use in EU law. It's not the terminology which is used in the bill. The bill refers to an indicative list of rules that would be subject to mutual recognition. Physical characteristics, packaging and labelling, production requirements, identification and tracing of animals, and so on and so forth. Now, what the bill does is then identify a second set of rules relating to trading goods, which wouldn't be subject to mutual recognition. They would be subject instead to the principle of non-discrimination, which is obviously a lower trade threshold than mutual recognition itself. Again, it gives an indicative list. For example, the circumstances or manner in which goods are sold, requirements relating to transportation or storage, and so on. The problem is that the bill creates this very clear distinction between two categories of rule. One set of rules will be subject to mutual recognition, another set of rules will be subject to non-discrimination, but it doesn't give us an exhaustive list into which category. So for those rules which aren't listed as illustrative examples, we've got to decide which category they fall into, and minimum price controls are not explicitly listed. So what we've got to do is figure out what the underlying philosophy is that distinguishes one group of rules from another and justifies their very different statutory treatment under the bill. And I think the assumption that we would make using our inherited EU heads is that mutual recognition applies to rules which would prevent the sale of a good based on having to change its inherent or innate characteristics, as it were, or any rule which would prevent the lawful sale of that good if you don't comply with the requirement. So it's not about the advertising of the shop premises, it's about the good itself. It would be completely orthodox in trade law terms to say that a minimum price, insisting that a good has to have a minimum price before it can be placed on the market lawfully, is no different from saying that it must have recycled packaging, or it can't contain dangerous chemicals, or it's such an inherent part of the good itself that I think you can align minimum price controls with the inherent product requirements such as packaging or labeling or composition. It is an open question, but in trade law terms, it would be completely orthodox to make that distinction.
Even though a bottle of English beer of the same strength was being sold at the same price as a bottle of Scottish beer of the same strength, that could still be counted as discrimination.
We're talking here about mutual recognition.
Sorry, we're talking about mutual recognition, right.
So I suppose the idea is that if the English beer, having been lawfully produced and sold and marketed in England, would actually have a significantly lower price than the Scottish equivalent, that by changing the price of the English beer, you are re-regulating a product which is already being lawfully placed on the market in England. And that's what mutual recognition is all about. The underlying idea of mutual recognition is that if a product has been lawfully placed on the market in one territory, it should be free for sale in every other territory without any further regulatory requirements to limit its access to the market. So by taking a bottle of English beer that might have been on sale for £1 and insisting that it has to be on sale in Scotland for at least £1.50, you are re-regulating the beer, you're imposing an extra regulatory requirement that has to be complied with before the beer can be lawfully placed on the Scottish market, and that's what mutual recognition is all about. It's unfortunate, I suppose, that the bill doesn't give us a more definitive list of which rules fall into which category, but in trade law terms, that analysis would be seen as completely orthodox.
John,
yes.
Just before you go on, John, I see Emily Lidegate's also said in the chat bar she'd like to make a comment on that particular area.
Right, could I make another point to Professor Dugan, and then come back to Emily, if I may? So, from what you said, Professor Dugan, if we're at £1.50 and it could be sold at £1, that's okay at the moment because that's the existing rule. But if we wanted to put it up to £2, we might be challenged in the courts.
Yep.
Okay, that was a simple answer. And then Dr. Lidgate.
I just wanted to raise a question that I've had about this bill, which is about how these market access principles would apply in the situation of divergence in labeling. So, this is explicitly identified in the internal market white paper as an area of concern, though I understand there is a harmonized agreement for a harmonized approach here. So let's say that a divergence in labeling occurred. Now, it's quite confusing to sort out which areas the mutual recognition provisions apply and which area non-discrimination. But I think in this case, I would argue that it would be mutual recognition that would apply to that, because it has to do with how the product is produced rather than how it's sold. But I think that would be a question that I would flag. But the principle of mutual recognition simply requires that the product be sold, not that it be standardized. So you could have a situation, for example, where let's say England decided that it wanted to change the threshold at which GMOs need to be labeled. So right now, I believe it's 1%, but they decided they wanted to change it to 5%. So then those labels would disappear from some goods. Presumably, those would need to be imported and be exempt from the labeling requirement. Or it could be something more cosmetic, just having different labeling requirements. So I think that's an example where actually a harmonized approach is more effective than just having mutual recognition, which would allow a proliferation of different approaches.
Okay.
Thank you, Emily, and thanks, John. Can I now go, please, to Dean Lockhart?
Thank you very much, Convener. I would like to come back to the question of how and when the internal market legislation might apply in practice. The UK and Scottish governments are both committed that common frameworks will form the vast majority of the trade in the internal market, as we've heard. And those common frameworks will set out common standards, but they will also set out areas of divergence for devolved regulation and areas of competent divergence for the devolved administrations. Previous evidence given to this committee has suggested that in reality the internal market proposals will apply potentially only to a relatively small area of trade which falls outside the common frameworks, and will, in effect, the proposals will act as an insurance policy or a sweep-up mechanism for trade not dealt with in the common framework. So I would like to ask the panel, do you agree that this outcome, if and when the common frameworks are in place, that we might see the internal market proposals in reality applying to a relatively small element of trade in the internal market? And perhaps if I could start with Dr. Lydgate on that question.
I think that would be the ideal landing ground, but I think that there's a lot of questions about how those common frameworks are constituted and how they are integrated into the proposed internal market bill. And I'll just give an example, because it really picks up on what Professor Dugan was saying about the dynamic nature of common frameworks. You can't sort of have a static agreement about what regulations are going to be, because they change. So the Scotland has this draft continuity bill which proposes continued alignment with EU rules, although it doesn't specify which rules. But this is, of course, significant here. So, for example, let's say that the EU decides to expand its restrictions on endocrine disruptors, which is something that's been sort of in the pipeline for quite a while. That would entail new product restrictions on a whole host of sectors: toys, cosmetics, food contact materials. And then the UK as a whole decides not to introduce these restrictions. So that puts Scotland in an interesting position vis-a-vis common frameworks. How would it integrate, or would it diverge? And if it did diverge, then it's in the unfortunate situation that it's imposing stricter manufacturing requirements, stricter requirements on its own manufacturing sector that aren't being imposed in the rest of the UK, and also required to import these non-complying products. So I think that common frameworks are definitely the way forward, but there's still a lot of questions about how those operate.
Thanks very much. And Professor Dugan, what's your views on that area?
Sure. I'm glad you came to me second. I had a chance to jot down four quick points. He said, holding up 5 fingers. Four quick points. First of all, just to endorse what Emily said, yes, of course, this is an insurance policy, but in a way, insurance policy makes it sound like it's something which might only be used as a last resort or in rare circumstances. It's an insurance policy in the sense that it's a default position, but that default position needn't necessarily be rare or unusual. It just means that as trade develops, as regulatory preferences change, as science and consumer demand throws up new challenges that regulators have to address, new barriers to trade will arise that fall outside the scope of the existing common frameworks. And the whole point of internal market principles, such as non-discrimination and mutual recognition, is that they provide the default insurance policy, if you like. I think the better phrase is default solution to the. I think the second point to make is that the UK government has made the promise that Brexit will lead to a significant increase in the devolved competences of Scotland and Wales. If that promise is true, then it means that this default insurance policy will actually have a more significant role to play. In a way, you can't have it both ways, if you know what I mean. You can't say that Brexit will lead to a significant increase in the powers of the devolved institutions, but then deny that the UK Internal Market Bill will only be a very marginal phenomenon. The more devolved powers you have, the more trade barriers you're capable of creating, the more you will need this bill to address them. So if Brexit does lead to a significant increase in devolved powers, this bill will have a commensurately greater role to play in regulating the way that those devolved powers operate in practice. I think the third point to make is, of course, that we're still in the process, I think, of negotiating and finalising those common frameworks. Obviously, if that process falls apart or begins to break down or doesn't produce the results that are required, again, the scope of application of this bill will be commensurately greater. And in a way, if I were being very cynical, and I'm not by nature a cynical person, but if I were being cynical, I would suggest that in a way, this bill is the insurance policy against the need for common frameworks. Because in a way, in trade law terms, we would ordinarily pitch sort of two absolutes in competition with each other. We'd say that if you really want to solve barriers to cross-border trade, you can either harmonise them, which is common frameworks, or you can use a strong principle of mutual recognition. But you don't need both, because one or the other will do the job. So if the harmonisation or common frameworks process fails, then a strong principle of mutual recognition will effectively do the job for you, because you don't really need harmonised frameworks anymore if goods are simply free to be produced wherever they're produced and then be sold wherever they want to be sold. So in a way, we can describe this bill as an insurance policy in a very different way. It's an insurance policy that almost removes the need for common frameworks to harmonisation if that process doesn't deliver the desired results.
Yep, well, thank you both for that response. I'd like to follow up on the dynamic nature of common frameworks, which I think is absolutely right. Once common frameworks are agreed, there will be significant areas of regulatory divergence recognised. So not just existing static areas in which regulations are divergent across the UK, but whole areas of devolved competence in which future changes in devolved regulation can be made. So, I mean, does the panel recognise that the common frameworks will build in future flexibility for the devolved administrations to change regulations in those areas, and whether to harmonise or whether to diverge within those devolved competent areas? Professor Duggan, perhaps you could address that one.
It's a bit like the distinction between on paper and in practice that I mentioned at the very start. Yes, of course, on paper, the common frameworks can leave scope for the exercise of devolved competence and the exercise of divergent choices, but nothing in this bill stops those divergent choices or exercises of devolved competence, even within the scope of common frameworks, from being subject to the principles of mutual recognition and non-discrimination, for example, in the field of goods. So in a way, what you're saying is completely true. On paper, the common frameworks are not some monolithic harmonisation that impose uniform rules across all of the territories. They do leave room for devolved competence, but this bill will still subject the exercise of those devolved competences to the principles of non-discrimination and mutual recognition. So ultimately, I don't think that the common frameworks is an answer to the problems that we've highlighted. It's simply the application of those problems in a slightly different regulatory context.
Convener, if I may follow up with Dr. Lydgate on a question or an issue she mentioned. Dr. Lydgate, you mentioned the potential impact of the EU Continuity Bill and Scotland keeping pace with EU law in the future. I would like to ask you, in terms of seeking harmonisation and common standards for the UK internal market, what potential impact could the keeping pace powers have on the objective of common frameworks and harmonisation in the UK internal market?
Well, it depends entirely on what the UK does with its regulation in the future, which I think is a question that many of us are interested in. But certainly, it opens up a wide scope for potential market access barriers between the Scotland and the rest of the UK, which of course would be addressed under this internal market bill, meaning that if EU regulations led to product-related restrictions or bans, Scotland would still need to import products from the rest of the UK and not discriminate against the way that they're labelled or presented. So I think there's certainly scope for direct conflict there.
Okay, Convener, I appreciate I've taken up a bit of time, so that's all I have. Thank you.
Thank you very much, Dean. Can I go to Patrick Harvey, please?
Thank you, Convener. Good morning to the witnesses. Can I first of all just follow up on this notion of the bill being either a default or an insurance policy compared with the negotiation of common frameworks? Can I suggest that the situation is actually even worse than Professor Dugan described? Because if this is a default, surely it actually weakens any incentive for the UK government to sit down, negotiate and compromise to reach a common framework by mutual agreement. If there's no incentive to do that, because they can always fall back on this default expectation of centralising power, then surely we have less likelihood of reaching agreement by negotiation and compromise. We're only going to get that if all governments, all parties throughout these islands recognise that reaching an agreement is a way of solving or avoiding a problem that they all find disagreeable. Surely this bill makes it less likely that we achieve that negotiated, agreed, mutual resolution to some of these issues. Professor Dugan.
Okay. Thanks, Patrick. I think when I suggested in my answer to Dean that the cynical bit of me might suppose that this bill was effectively a way of not having to worry too much about either common frameworks or future needs of harmonisation, I might have been expressing the same point in maybe a more diplomatic way. But I agree. It's in a way, this bill cuts across the whole debate, not just about common frameworks right now, but also about what might be the framework for future common frameworks or harmonisation, whichever term we want to use. If we accept that internal markets are dynamic phenomena which need to be constantly managed, and it's the process of managing the internal market which is actually just as important as the substantive outcomes that you reach, then of course one of the questions we've got to address is what's the right balance between having these principles of mutual recognition and non-discrimination, whereby different territories can go their own way, but we find a method of managing the trade implications of that divergence, or how far do we decide to harmonise, to establish common frameworks, and to somehow come up with the same solutions or similar solutions to comparable problems. And of course, many systems, including the EU system, are engaged in constantly striking a balance between these two things. When should the EU harmonise, or when should it leave it to Cassis de Dijon and the operation of market forces through the control of the principle of mutual recognition? In a way, what Patrick says is completely right. If you have a very strong principle of mutual recognition, or Cassis de Dijon on steroids, then it weakens the need for common frameworks for harmonization, because you can achieve effectively the same result through the operation of market forces rather than centralized regulatory intervention. If obviously you have a default solution, then it weakens the incentive to engage in the more complicated process of negotiation and compromise. So maybe I've just made the point in a more diplomatic way, but I agree with that.
Sure. So, I think it sounds as though it will leave us in a similar position to the legislative consent mechanism at the moment, where the Scottish Parliament or the Scottish Government will be asked, please consent to this, or we'll do it anyway. That will be the kind of power imbalance that we'll have. Both witnesses, I think, have recognised that there's a bit of an assumption going on here that any kind of regulatory divergence or difference is an unacceptable trade barrier, and that actually internal markets do have differences, they do have divergence. Surely we should work to the principle, or at least there is a strong case for working to the principle, that it's only where there are incompatible rules or standards that we really have a problem that can't be resolved in the normal democratic way. I'll give one example. One of the first policy areas mentioned in the Internal Market White Paper that preceded the bill was on building regulations. That's been fully devolved for over 20 years. It was separately administered even before devolution. If two jurisdictions within the UK had different standards about how efficient insulation products need to be, then a manufacturer can decide, am I going to meet one standard or both? Manufacturers are free to decide whether they'll comply with both standards. But we only really have a problem if one jurisdiction said it has to be minimum 60% organic material in that insulation product, and the other jurisdiction says it has to be minimum 60% synthetic material, because a manufacturer is incapable of meeting both standards. Isn't there a case for saying that's the principle we should be identifying? That's where we should be saying there is a problem, only where it's impossible to comply with both. Can I ask Dr. Lydgate first, and then Professor Duggan to respond to that?
Well, I think that has been the approach, basically, of the EU, is to allow divergence where possible, but when harmonization is necessary for free movement, it will be required. But within that, there is scope for divergence, as long as countries are willing to put up with the sort of market access barriers that you identified. I think that's where the market power issue comes in, because if you have a much larger much larger economy with much more construction going on, then it makes more sense for manufacturers to produce products to that standard than have a separate supply chain. And you can see an example of this would be in the trade agreement between the EU and Canada. Canada got increased low tariff access for beef, but it hasn't used that. It hasn't exported to meet anywhere near its quota, because all of its supply chains are set up to feed into the US market. So it's just simply not economical for those farms to set up a separate supply chain just for the EU market. So I think that's where the sort of logic of market size comes in.
Any comment on this from Professor Duggan?
Sure. I think this is a useful point at which we can draw a direct contrast between the EU practice and the proposals contained in this bill. But everything really depends upon our starting assumption. Trade law gives us a toolbox, and it provides us with a range of ways that we can manage markets, but it doesn't tell us what the best combination of those tools should be. We still have to make a value judgment to start off about which tools we want to use. In the EU context, the basic assumption is that we want a well-regulated market which is left to the member states unless the barriers to trade which are created are of such a nature and scale that they require centralised harmonisation. So the way the EU system works is that by default, member states regulate their marketplaces as they see fit, subject to the principle of mutual recognition. But mutual recognition provides a broad range of exceptions and derogations where member states can justifiably maintain trade barriers for all manner of legitimate public interest reasons. When a member state does that, it effectively flags up to the Commission that there is a trade barrier, it's a legitimate trade barrier, maybe we should think about harmonisation. And then the emergence of legitimate trade barriers acts as a kickstart to the process of political dialogue, whereby the member states and the other EU institutions begin to think about just how serious a problem this is, what is the best solution to adopt in relation to it, and so on. So in a way, we could almost say that mutual recognition in the EU context is like a problem identifying principle. It basically says, here is a problem, how are we going to solve it? The problem with this bill, in a way, is that mutual recognition isn't being used as a way of identifying problems so as to help find a political solution to their resolution. Effectively, this bill is saying, we've identified a problem and we're going to sweep it aside through the operation, in effect, of market forces. And if you want, you can think about this bill as effectively subjecting the exercise of devolved competence to market forces. In a market where England makes up 80 or 85% of market share. So I think in a way that sort of answers your question in a roundabout way, that the starting assumption of this bill is not that the exercise of divergent regulatory preferences is an issue that we need to address through political dialogue to identify legitimate public interests and decide when barriers to trade are justified or unjustified and how best to address them. In a way, the underlying starting point of this bill is the exercise of devolved competence creates problems that we need to sweep away. And the tool we'll use to sweep that problem away is market forces through the sheer size of the English economy. So that in practice, it's the English choice which will prevail, not the Scottish or the Welsh choice. That's a very, very different starting assumption from the EU, for example.
No, thank you. That's I think that's quite powerfully put. My last question that I wanted to explore with you both actually leads on from that, because I have a concern that this isn't just about sweeping away devolved competence, but sweeping away democratic accountability. The judgment about whether a form of divergence or a potential market barrier is acceptable or unacceptable should be a democratically accountable judgment. And whether we see decisions being taken into the courts or being centralised to the UK government or otherwise being taken away from parliamentary accountability, then we have a problem. It seems to me, and I wonder if you could respond to this, that even if we got a system of derogations and justifications added into this bill, that would still be unacceptable in terms of democratic accountability, because it would be the devolved government that would have to apply for that derogation before it was then able to make a regulatory proposal to Parliament. There has only been one session since devolution began where a single political party had a majority in the Scottish Parliament. And if you accept the principle that ministers don't represent a majority until Parliament has voted, then surely derogations for which ministers have to apply still an inadequate democratic lock, the kind of choices, the kind of legitimate choices that the Scottish Parliament or other parliaments ought to be able to make. Professor Duggan and then Dr. Lydgate.
Sure. I think in response to a couple of the earlier questions, I indicated that my sort of baseline for improving this bill would be to widen the system of derogations and justifications. But that really would be the bare minimum baseline, sort of taking the bill as it stands and seeing how it could be readily amended. I really think one of the problems with this bill is that it's trying to replace processes of dialogue and negotiation to find political solutions to how to address the problem of barriers to trade, not only with our starting assumption that this is a problem that needs to be swept aside. It's the way that it proposes using quite automatic, legally enforceable principles applicable before the courts to do the job for it. And I think that's why I suggested that my preference would be that the trade issues created by the UK internal market are managed through a system of pre-legislative dialogue. Now, it's probably not for me to try and speculate about whether that's best done by governments or parliamentary committees, but I think a system of pre-legislative dialogue that actually tries to have a political and an accountable debate about whether a problem exists, the nature of the problem, the scale of the problem, and the most appropriate solution would, to me, be far preferable than an automatic legal rule. It's not even an assumption, it's virtually an automatic legal rule that regulatory divergence is a problem that needs to be swept aside in practice.
Thank you. Dr. Lydgate, anything to add on this point?
I was going to also call attention to the fact that this brings up the question of who is deciding, who gets to determine whether a derogation is legitimate. And there's quite a lot of power for the courts here. Another thing that really struck me when reading this bill is just the complexity of the drafting. So there's so many terms to interpret, relevant connection, relevant requirement, direct and indirect discrimination, et cetera. So I don't think that that's, I would agree that replaces a political process with a judicial process, and that there should be some other way of resolving these issues on the intergovernmental level. I think another question here is about this CMA, which has been empowered with an advisory oversight role, which strikes me as being quite a bit beyond the type of competences that it has now. Not to malign that body, but it seems to me that it would be appropriate to make sure that there is representation from devolved nations in that body, and just to ensure that it has a range of competence to be able to oversee some of these issues, which can be, I think, quite technical and specific to certain sectors.
Yeah, and that presumably would require expertise in environmental governance, public health, and so on, which are also not factors in the appointment of the board of the CMA.
Exactly.
Thank you both very much. Thank you, convener.
Right, thank you, Patrick. Jackie Bailey, please.
Gina and Patrick Harvey's questions lead neatly onto the area I wanted to explore. Can I ask Dr. Lydgate first? Because obviously both of you have talked about the need for new governance structures, the need for dialogue, negotiation, the complexity of it. So I'm kind of wondering what you think the institutional architecture needs to be like to make this work. And I'll go to Dr. Lydgate first.
I think, well, I would bring up the question of transparency. I mean, I have no idea what's going on in the Common Frameworks discussion. I think a lot of us are interested in how robust those are and how they're progressing. And I think there's an analogous problem with respect to the role of devolved nations in in trade negotiations. So we know that they're thinking of having this Concordat on international trade. I don't think that's appeared, and I don't really have a sense of what that looks like. And in contrast to the Internal Market Bill, which is all set out, what are the procedures, what are the competences. So I think that there's some real asymmetry here, and simply putting some of the devolved nations' inputs into a more into legislative form would be useful in the context of a kind of lack of trust, and also developing dialogues which have a formal role in the end results. So I'm not sure, because devolution is not my area. I'm a trade lawyer, so I'm a little bit hampered in spelling out exactly how that would happen. But that's the sort of the gist of it, I would think.
Sure, and Professor Duggan earlier talked about pre-legislative dialogue, but I'm conscious in the European Union, there was the European Commission, there were kind of neutral, independent governance architecture that appears to be missing from this bill. Do you think there's a need for that? Almost
Absolutely.
Like a dispute resolution mechanism.
Yes, and I think the question is not just about having the body. It's about defining the powers of devolved nations to essentially steer the discussion. So, and again, I'm not sure what the best way to do that is. I think I defer to Professor Duggan on this one.
Okay, Professor Duggan.
Thanks. Like Emily, I'm not a devolution specialist. So what I'll do is I'll use the system which I know very well, the EU system, and then draw out the features which I think distinguish it from the current UK situation in this bill. I think the starting point is a fairly essential proposition that the principle of mutual recognition, and indeed most trade principles, but especially the principle of mutual recognition, depends on mutual trust. And the two go completely hand in hand. It's very difficult to have a situation where a territory is simply expected to let imported goods, imported services be freely available to its citizens, to its consumers, without any further or additional regulation, without having to comply with its own local legislation, unless you have a high level of mutual trust between all of the participating territories, that they'll all respect certain common values, certain common standards, and that the rules will apply fairly between them. A huge amount of the EU's institutional and governance effort goes into creating the underlying mutual trust that makes the system of mutual recognition and harmonisation work. It's why, for example, we have a very complicated legislative process at the EU level that tries to balance the interests of the large member states and the small member states. It's why we have the Independent Commission, which is meant to oversee the operation of the single market without any influence from any given member state itself. It's why we have an independent dispute settlement mechanism through the Court of Justice, so that there's a judicial body which is independent of any of the participating territories. Even then, we see in the EU context what happens when mutual trust breaks down. We've seen it in fields such as criminal law cooperation, but we've also seen it more recently, for example, in the field of medical supplies when the pandemic hit the EU. When mutual trust breaks down, mutual recognition breaks down as well. So I think the key challenge which the UK has to think about is how do we maintain a system of mutual trust that would justify and make operational the core principle of mutual recognition that underlines this bill. And I think the problem is that the bill does nothing about that issue. It simply assumes that the principle of mutual recognition can be transposed onto the UK's existing empirical and constitutional structures, and it will operate per se automatically as a set of rules to deal with trade problems. I'm not sure that's a sustainable political proposition or constitutional proposition. So I mentioned things like having a pre-legislative dialogue whereby the four territories would sit down and think about potential trade barriers and how best to resolve them through an agreed political solution. But of course, even that presupposes a level of mutual trust and cooperation between the political actors involved to make that system work. And I suppose one of the concerns which has been raised about the UK internal market as a phenomenon is that at present there appears to be, for a private citizen like me, it certainly appears that way, there appears to be not that mutual trust between the administrations which currently govern different parts of the UK. So I think my answer would be mutual recognition requires mutual trust. And one of the big lacunae in this bill is that it does nothing to try and create the institutional framework that would generate the mutual trust that could possibly justify such a strong market system as the bill itself proposes.
Thank you very much, Professor Duggan. That was very helpful indeed. Thank you, Convener.
Okay, thank you, Jackie. Thank you very much. Can I thank our witnesses, both Professor Duggan and Dr. Lydgate, for their very helpful evidence today. I now suspend this meeting to ensure the next witness is in place, and will recommence at 10:30. We now turn to taking evidence on the Trade Bill 2020 and its associated legislative consent motion. First, we will hear from the Right Honourable Greg Hands MP, who is the Minister for State of the Trade Policy with the UK Government. I warmly welcome Mr Hands to our meeting and I invite him, if he so wishes, to make a short opening statement.
Yes, thank you, Mr Convener, and thank you for inviting me to attend the committee today, and I hope that you can hear me okay. If just to give an indication, I can't. Fantastic, thank you. And I look forward to the discussion and assisting the committee today with its scrutiny of the trade bill. Convener, as you know, I first appeared in person at your committee in March 2016 on the fiscal framework. And I take my action with the Scottish Parliament very seriously, and it's good to be back with you again today. In relation to today's bill, I'd like to emphasise that as with the 2017-19 trade bill, which the committee considered in 2018, this trade bill covers only those trade agreements the EU had in place as of the 31st of January 2020. As such, and as the Scottish Government has noted in its legislative consent memorandum, the trade bill is essential in providing certainty, continuity and stability in our existing trading relationships for businesses and consumers in all parts of the UK. Throughout the passage of both trade bills, we have taken significant steps to address the issues and concerns raised by the Scottish Government and by this committee. I am pleased that this has led to the Scottish Government to recommend consent for all of the relevant clauses, and I hope that our discussion today will lead this committee to support it as well. The main clauses for which we are seeking consent are those relating to the concurrent powers in the bill, which will be used to implement the trade agreements that we are transitioning. As parts of those agreements touch on devolved matters, we have put in place these concurrent powers to provide greater flexibility in how continuity agreements are implemented. This will allow each devolved administration to implement the agreements independently in some cases, but also allowing the UK government to legislate on a UK-wide basis where it makes practical sense to do so. When the committee scrutinised the previous bill, some of its members expressed uncertainty about how and whether the agreements would be transitioned. However, since then, 20 continuity agreements have been signed with 48 countries, covering trade worth over £110 billion sterling in 2018 figures, which represents 74% of the trade with countries with whom we were seeking continuity before the withdrawal agreement was signed. The UK Parliament has had the opportunity to fully scrutinise all the continuity trade agreements we have signed, in line with the framework set out in the Constitutional Reform and Governance Act 2010, also known as CRAG. And parliamentary reports have been laid alongside each continuity trade agreement to explain our approach to delivering continuity with each partner after the transition period ends. These reports make clear that all the agreements signed to date provide for the maximum level of continuity. Any changes that have been required to achieve this in practice have been set out and explained. I hope this provides the committee with greater clarity about what the concurrent powers will and will not be used for. But I also recognise that the devolved administrations and their legislatures want additional reassurance that the powers will be used appropriately. That is why we have committed to not normally use the concurrent powers in areas of devolved competence without consent of the relevant devolved administration or administrations, and never without consulting them first. This is one of the many commitments and amendments we made at the request of the devolved administrations for this bill. These are set out in full in the Scottish Government's memorandum. In particular, I'd like to highlight the amendment we have made in relation to the restrictions on devolved ministers' use of the powers in the bill. The Scottish Government and this committee raised concerns about the restriction in the Trade Bill 2719 relating to Section 12 of the EU Withdrawal Act. We have listened to these concerns and have removed this restriction for the Trade Bill 2020. We have taken great steps to ensure that this bill reflects the views of the devolved administration and legislators, and I'm confident that the bill respects the devolution settlements. While outside the scope of this bill, I know that the wider role of the devolved administrations in international trade is of great interest to the committee, Mr. Convener. We have now established a ministerial forum for trade with devolved ministers that meet regularly to discuss all aspects of our trade policy. It had its inaugural meeting in January and has met twice since then. I chaired its most recent meeting in July, where we discussed the progress of all of our negotiations in detail. I have also had regular bilateral discussions with Scottish Government Minister Ivan McKee, from whom I think you're hearing after me, most recently on the conclusion of the Japan agreement just the week before last. We have also established structured engagement at the official level, both at the every 6 weeks senior officials group and regular updates to devolved administration officials from our chief negotiators. This is supplemented by day-to-day engagement on the technical detail of our policy. The impact of this engagement can be seen in how the Scottish Government's perspective has been reflected in key parts of the UK-Japan Comprehensive EPA, or Economic Partnership Agreement, agreed in principle earlier this month. The Scottish Government made it clear that greater ambition in financial services would be something they want to see prioritised. This is reflected in the improved market access we have secured for UK financial services, including greater transparency and streamlined application processes for UK firms seeking licenses to operate in Japan. The deal also creates an annual dialogue between HM Treasury, UK financial regulators, and the Japanese FSA that will explore ways to further reduce regulatory friction, something that would be impossible were the UK still in the European Union. Financial services are one of Scotland's largest exports, so I think this example clearly demonstrates the benefits that Scotland stands to gain as part of this agreement and our wider independent trade policy. To take another example, Convener, Scottish stakeholders have emphasised the importance of geographical indications, GIs, and again this agreement secures additional benefits beyond the EU-Japan deal. This means that iconic Scottish products such as Scotch beef and lamb could be protected in the Japanese market for the first time. In essence, Convener, this bill is about continuity and about certainty. Continuity of the existing trade agreements that we had through our membership of the EU, and the certainty that continuity offers for businesses in Scotland and throughout the UK, an especially important matter in this time of global economic uncertainty. We are determined to continue to effectively engage with the devolved administrations across all areas of trade policy to achieve this. I look forward to continuing our dialogue to ensure this cooperation is successful. Thank you again for today's session, and I look forward to any questions from your committee. Thank you.
Thank you, Minister, for that detailed and helpful opening statement. If you don't mind, I'm going to begin the questions at this stage. Minister, during the House of Commons scrutiny of the bill, you explained that as trade agreements under this bill had previously been scrutinised as EU agreements, it would not be proportionate use of parliamentary time to give those agreements further scrutiny. However, as the government notes in its LCM, the powers could also potentially be used in the implementation of entirely new trade arrangements in circumstances where those agreements with the trading partners who have an existing agreement with the EU. So my question is, why doesn't the bill therefore provide for devolved parliamentary scrutiny of each rolled over agreement to enable proper scrutiny of new parts of rolled over agreements in devolved areas of responsibility?
Yeah, well, thank you, Convener. And that's you're right. This has been a question or area of question that has featured throughout the trade bill. As I may have mentioned, I actually, rather unusually for a minister, I've taken this trade bill through the House of Commons twice, both the 1719 trade bill and now. I'd say a few things to that. Of course, the only agreements that would be, the only countries that would be in scope of these powers are countries for which the EU had a trade agreement signed before the 31st of January. So that would exclude, for example, the United States, would exclude Australia, would exclude Mercosur. So it'd be purely for agreements with the countries with which the EU had a trade agreement, to be first clear on that. Secondly, the purpose of the continuity programme is in general to stick as close as possible to the original agreement. Again, taking us all the way back to 2016, a judgment call was made by the UK government that the trying to reopen all 40 of these agreements would be both practically rather difficult and might make it the case that we were unable to roll over enough of those agreements in time, which of course was originally envisaged for being March 2019. So we basically decided to stay as closely as possible, in which case the agreements that have been rolled over, of those 40, the 20 so far, stick very close indeed to the original agreement. They've been, as you rightly point out, through the existing House of Commons and House of Lords scrutiny system, scrutinised as EU agreements. However, as you also rightly point out, there is scope for a new agreement or a substantially changed agreement based on the original agreement to happen, which is actually closely to what we've just done with Japan, which I talked about in my opening statement. And here we've laid on additional scrutiny at the UK level and additional interaction with the Scottish Government and the other devolved administrations. So I've talked at all stages, the Scottish Government Minister Ivan P, through what we've been doing with Japan, and as I mentioned, I had a call with him, I think it was just last Monday, taking him through a lot of detail of the agreement. What we've done in the UK Parliament has been we've had additional scrutiny of the Japan agreement. The Secretary of State has made an oral statement. We've tabled, of course, before we did the agreement, a scoping assessment. We'd be negotiation objectives for the Japan agreement and so on. So all of these things on top of what one would normally have expected for just a simple rollover agreement. And then, of course, there is the ability of the House of Commons to scrutinise the agreement further. We'll also be publishing the impact assessment next month, and then there'll be the opportunity for both Houses of Parliament here in the UK to scrutinise that agreement through the CRAG process, or the Commons through the CRAG process, and also the Lords as well, if it wishes to do so. So I think you're right to ask that question, and it's been asked a few times, as you rightly point out, before during its passage. But I do think that the arrangements in place are both proportionate and allow sufficient parliamentary scrutiny, particularly of new agreements with countries with which the EU had an existing agreement on the 31st of January 2020.
Yeah, thank you for that answer. But I think you can probably see the Scottish Parliament's dilemma here a bit, because where there's a new part of a rolled over agreement that engages devolved areas, whilst there may be consultation with a Scottish Government Minister, there's no formal role in legislation that enables the Scottish Parliament to give a view on whether or not that trade agreement, rolled over new part, is appropriate or otherwise. And I think that's something I would ask you to the UK government and yourself to have another look at, to ensure that, as far as the devolved Parliament institution is concerned, that their proper scrutiny role is recognised.
Well, thank you, Convener. I'm very happy to have a further discussion with, particularly with Minister McKee, as to how your scrutiny might be able to kick in here. Look, I'm very keen to work with yourselves and make sure that the Scottish Parliament is involved in our trade policy. I mean, it is so important. I mentioned the Japan deal and the US deal. Of course, the scoping assessment shows that Scotland will benefit the most of any nation or region of the UK. So, of course, I'm keen for you to have an appropriate role whilst respecting the devolution settlement and respecting the fact that international trade is a reserved matter, but clearly does have consequences at a devolved level. So I'm happy to take that away and reflect on what you've said, and perhaps speak with the Scottish Government as well, and see what we can do.
Yeah, thank you very much for that commitment. It's very helpful, Minister. As a committee, we've previously stated in a number of reports, including our previous trade bill, LCM report, that provisions that would allow UK ministers to make statutory instruments in devolved areas without any statutory requirements to seek consent of Scottish ministers, or indeed the Scottish Parliament, cuts across the devolution settlement. You've confirmed in the House of Commons your commitment that UK government ministers will not normally use the powers conferred in the bill in devolved areas without Scottish and other devolved ministers' consent, and never without consulting them. That's helpful. But why isn't that commitment on the face of the bill?
Yeah, well, thank you, Kavina. And I think that is, you're right. We've come to a good arrangement that we will not normally use the powers within areas of devolved competence without the agreement of the devolved administration, and never without consulting them. And I think that is the right course. I think the reason it's not on the face of the bill is purely a question of the legal status of international trade being a reserved matter. And I think it's important for us to keep that and to make sure that we work well together, the two governments, in this space. I don't think it's necessary or desirable to put that on the face of the bill, which would then, if you like, have the potential to erode the legal status of international trade as a reserved matter. So, to be honest, I think the arrangements we've got in place will work well and have worked well so far in terms of the discussions that we've had with the Scottish Government on the 20 agreements that we've already rolled over, for example.
Okay, I hear your answer. I'm going to move on and let Murdo Fraser ask the next question, but I'm going to say I'm a bit sceptical about whether or not it would undermine the position of the UK government in the way you've outlined, because it's already enshrined in various pieces of legislation through the Sewell Convention, so it would be no different to that sort of area, but whatever we might think about the Sewell Convention. But Murdo Fraser, over to you.
Thank you, Convener. Good morning. Good morning, Mr. Hands. Good morning. I've got a couple of questions about the need for the bill, but just before I come on to that, I wonder if I can ask a follow-up question to the convener's line of questionings about the bill. And I mean, you rightly said it's important we respect the devolution settlement, and trade policy is a reserved matter to Westminster. And you also said that there's an undertaking that UK ministers will consult with the devolved administrations. But would you agree that to effectively give devolved administrations a right of veto over future trade agreements would not be in line with the devolution settlement?
Correct. I think that is, thank you, Mr. Fraser, I think that is absolutely right, that there should not be a veto. And here, it's very important because Scottish producers, Scottish consumers also need to have access to those important UK trade agreements going forward. And we need to make sure that that the trade agreement will apply throughout the four nations of the United Kingdom and throughout all regions of the UK. And I think that's very, very important. Also for those looking to export out of Scotland, I mentioned Japan earlier, and consumers in Scotland. So I think it is important that the reserved nature of trade policy be respected and that there not to be a veto by any of the three devolved administrations.
Okay. Thank you for that. I wonder if I can move on and just ask a bit about the background to the bill and the need for it, and really why it's required, and what would be the impact for Scottish business, Scottish exporters, if this trade bill were not put into place, and would there, for example, be a risk of damaging competition from some competitor countries like China?
Yeah, well, I think if this trade bill did not get to the statute book, and it is currently going through the House of Lords, it completed its passage through the House of Commons back in July and has had second reading in the Lords, so the passage is going well so far. I mean, I think there would be major implications. If I could just mention the four principal areas of the bill would have implications at all four. For example, that it could endanger the UK's accession to the Government Procurement Agreement, which is what's called a plurilateral World Trade Organization agreement of 20 countries, which allows access to each other's procurement markets. So this would be UK businesses having access to procurement bids in, say, the United States, Australia and Japan and other countries. Also, that would have an impact on those who were doing tenders in Scotland, for example. So Scottish bodies, government bodies who are doing tenders wouldn't necessarily be able to get the best price or the best service if it was no longer in the government procurement agreement. Secondly, I think in terms of the 40 EU trade agreements, some of these are extremely important. The agreements with Japan, we've already talked about, Canada, Switzerland, South Africa, there's a considerable amount of trade. I think the figure is about £110 billion sterling, which could be at risk if this trade bill didn't become law. On trade remedies and trade defences, the establishment of the Trade Remedies Authority, and not having that set up in statute, I think could have significant implications for our trade defences. So when we're taking action against the dumping of, say, steel goods or ceramics into the UK market from producers in countries like China, then the legal basis of us taking those actions could be called into question without the legal setup of the Trade Remedies Authority. And the fourth area is on the data sharing powers, the ability to share trade data at HMRC and beyond. Could also be called into question without the bill passing through and becoming an act. So I think the implication is very much about continuity, and the implication for a lot of the UK's current trade practices could be very severe indeed if the trade bill did not become law.
Okay, thank you. Thank you. It's a very comprehensive answer. And just one final question, if I can, Convener, just so we're clear, this bill only deals with existing trade agreements that have already been entered into. If there are any new trade agreements negotiated, these will require a separate mechanism and a separate legislative vehicle. Is that correct?
That is absolutely correct. So it only applies to countries with which the EU had a trade agreement prior to withdrawal date on the 31st of January 2020. As the convener rightly pointed out, that could theoretically apply to a new trade agreement with one of those partners, which is what we've done with Japan, but it does not apply to countries with which the EU does not have a trade agreement, for example, the United States, Australia, Mercosur, India, etc., etc.
Okay. Thank you. That's very helpful.
Thank you, Margot. Tom Arthur has indicated he is a supplementary in this area. Tom?
Thank you very much, Convener, and good morning, Minister of State. It's just a very brief supplementary to a point raised by Murdo Fraser, in which I understood you agreed with Minister of State, which is that the devolved parliaments, of course, don't have a power of veto, and that, in the view of the UK government, we should not have a power of veto. Just to look at the corollary of that would mean that the UK government does have and should have a power to impose. Should a scenario arise where the Scottish government and the Scottish Parliament and a majority of Scottish MPs are opposed to a trade proposal by the UK government, either under this bill we're discussing or any other future agreements, what should the UK government's response be? Is the UK government minded to perhaps press the pause button and seek to engage in discussions to go and try and find consensus? Or is the UK government's view that, well, this is a reserved matter and it's for the UK government and the UK Parliament to decide?
Well, thank you, Mr. Arthur, and it's a good question. And the answer is always to engage in discussion. I mentioned earlier, it's always been a priority of mine since I was here at our department at its inception to make sure that our international trade policy has got support in all four nations of the United Kingdom. The policy is designed to benefit all four nations of the United Kingdom. I mentioned earlier, for example, the United States, the scoping analysis for the US agreement shows that Scotland will benefit more than any nation or region of the UK from doing a free trade agreement with the United States. So my starting point has always been that it is our intention, firmly our policy, to make sure that all four nations of the UK benefit. The second thing I'd say is that we also interact very frequently, very strongly, directly with Scottish businesses, Scottish consumers. Just last week, I was talking with Scottish Chambers. Later today, I'm doing a British-American business webinar with businesses in Scotland on the UK-US free trade agreement. We've got, as you probably know, on our Trade and Agriculture Commission, the Scottish NFU. I've met with the Scottish NFU recently, Scottish Smoked Salmon Producers Association, a lot of bodies directly in Scotland. And the third area is interaction directly with the Scottish Government. Since I returned to being Minister for the devolved aspects of trade in May, I've had 5 meetings with Ivan McKee, who you'll hear from later. And look, I'm not telling you anything you don't already know, that Ivan and I, we don't agree on everything. But that interaction is very strong and very frequent. So I don't think we would get to a position where we would have a trade agreement, I would hope, that would meet a strong opposition with any of the 4 nations of the UK or any of the English regions. I just don't think that would be the case. But I do think it's important not to have a veto for the devolved administrations, but I don't think we would be in a position where we would do a trade agreement that will be wildly unpopular in one of the 4 nations of the UK.
So you would recognise that you're absolutely committed. You want to avoid a scenario whereby the Scottish Government and the Scottish Parliament and the majority of Scottish MPs would be opposed to a trade deal, but the UK Government chooses to go ahead with it anyway. So you're absolutely committed that that's something you want to avoid, and you will work, and you will strain every sinew to make sure that doesn't happen.
Well, look, as I said, Mr. Arthur, our objective is to have a trade policy that works for the whole of the UK. That is what we've done so far in the 20 rolled over agreements. I don't think anybody has pointed out anything in those 20 rolled over agreements that would be unpopular or detrimental to Scottish interests. And it's very much our intention going forward that we negotiate on behalf of the UK, which is exactly what the Scottish people would expect us to do, negotiate on behalf of the whole of the UK and to get agreements that work for the whole of the UK. You know, I'm acutely aware of the importance of Scottish goods and services in our trade policy. I mentioned I meet with Scottish producers and businesses very, very regularly on both goods and services. And we need to make sure that they benefit from those trade agreements. In my world, of slightly wonkish world of trade policy, you can often get bogged down in aspects of trade policy and the esoteric side of it. But if it doesn't work for businesses and consumers, that is the most important thing, is to deliver things that will benefit businesses, benefit consumers, and that applies to all 4 nations and all regions of the UK.
Okay, thank you.
Thank you.
Right, Angela Constance, please.
Thanks very much, Convener. I mean, obviously, we all understand that the essence of this bill is about rolling over existing agreements, but the Minister on a number of occasions today has made quite loose statements about how Scotland should be involved in trade policy. And I wanted to highlight to the Minister that the Constitution Committee, not this Constitution Committee, but the Westminster Constitution Committee in 2019 recommended a role for devolved nations in negotiation and scrutiny of trade agreements, and that they should be, I quote, be effectively involved. So what I would like to put to Mr. Hands is, surely devolved nations being involved amounts to something more than Greg and Ivan having a wee chat on the phone, or indeed the Minister doing his job by engaging with Scottish business, which we would all accept is vitally important, but a bare minimum of his job description, I would suggest. So can Mr. Hand say whether or not he agrees with the Westminster Constitution Committee and how going forward he will or will not implement the recommendations of that committee?
Yeah, well, thank you, Ms. And let me go into a little bit more detail about the interaction that we have, because it's not just at ministerial level. It's very important for us to involve Scottish Government officials as well. We have every 6 weeks a senior officials group that meets between UK Government officials and Scottish Government officials to discuss trade policy, and I think that has been going well. We have the Ministerial Forum for Trade, 3 meetings so far this year, myself, Ivan, Baroness Morgan and Diane Dodds in Northern Ireland, and that is also going well. And it's this kind of thing that enables us to have those regular, frequent interactions. As I say, I talked to the Scottish Government Minister on the specific agreements coming up. We had a very good discussion on Japan, for example, and we make sure that I'm constantly asking him, and you could ask him this, I'm constantly asking him, what from the Scottish Government's perspective would be your main asks coming up in these different agreements. So I make sure that Scottish Government and the other devolved administrations, that their asks are listened to, and also directly with Scottish businesses, as you'd expect me to do. So I think that structure is working well. I think your involvement as well and your scrutiny as well is very welcome.
What about the Constitution Committee's recommendation that devolved nations should be involved in negotiation and scrutiny of future trade agreements? I mean, do you have a view on that? Agree? Disagree?
I don't agree with the devolved administrations being at the table when the negotiations are happening, but I do agree with the regular interaction and regular briefing of ministers and Scottish Government officials of what's going on in the negotiation, what we think is happening with the agreement. We'll be sharing the text of the Japan agreement. It's currently going through legal scrubbing. We'll be sharing the text of that agreement, and we allow significant access to the Scottish Government and the other devolved administrations throughout the process. So I think that is the appropriate level, whilst respecting that international trade is a reserved matter.
Okay, so you disagree with your own Westminster Committee about involvement in negotiations and scrutiny, and we'll just stick to a little bit of chat. Can I move on, Kavina? I've got one final question for Mr. Hands, and again, it's recognising the scope of this bill, what this bill isn't about, but crucially, I think we're all looking to the future. And I wonder how Mr. Hands, in terms of establishing future economic and trading agreements, how he proposes to overcome the reputational damage that the UK has inflicted upon itself as a result of its internal market bill and their own admission by UK government ministers that it breaches international law. And of course, we've heard from Tory grandee after Tory grandee that who on earth is going to believe us in terms of establishing future arrangements that we will indeed uphold what we sign up to. We've had Michael Howard expressing his concern about the UK Parliament using its sovereignty to break international law. So what's Mr. Hands going to do to repair the damaged reputation of the UK government in terms of future trade agreement?
Well, look, I mean, thank you for that question, Ms. Constance. And the UK Internal Market Bill is an entirely separate piece of legislation. It's not a piece of legislation being led on by the Department for International Trade. I would say two things. I think the UK bill is essential for the good operation of the UK's own internal market, which is incredibly important for Scottish businesses. I might point out that the amount of goods leaving Scotland to the rest of the UK is actually vastly larger than the sort of volumes here I'm talking about in terms of international trade. So I think in terms of the impact on Scottish businesses and being able to sell their produce and services into the UK market, the UK Internal Market Bill is incredibly important.
Forgive me for interrupting, Mr. Hands, but the nub of my question was really is who's going to trust you if your own government isn't going to stick to its word when you have to traipse around the world and negotiate, whether I like it or not, trade agreements on all of our behalf. Who's going to trust you that you'll stick to your word?
Well, since the row about the UK Internal Markets Bill, which, by the way, I absolutely stick to my guns that this is an essential piece of legislation and a very important piece of legislation for businesses in Scotland. Since that row, we've actually done the agreement in principle with Japan on the UK-Japan trade deal. Has actually happened since then. So the Japanese clearly trust our word when it comes to international trade agreements, which I think was the basis of your question. The proof there is in the pudding.
Well, we heard some interesting evidence to speak about the Japanese agreement, but we'll leave it there, Convener.
Well, yeah, we'll move on. Dean Lockhart, please.
Thank you very much, Convener, and good morning, Minister. I would like to follow up on the Economic Partnership Agreement signed with Japan. Last week, I chaired a meeting of the Scottish Parliament's cross-party group on Japan, and the Consul General of Japan highlighted that under the EPA, there were a number of increases in the Scottish products benefited from protected geographical indication, meaning that Scottish produce such as salmon, cheese, wool and beef will now all have much better and freer access to the market in Japan. I wonder if the Minister could expand on the opportunities available to Scotland and business in Scotland under the EPA, and is this a good example of how future free trade agreements will be concluded after the transition period?
Yeah, thank you, Mr. Lockhart. And I think that it is a good example. It actually takes the EU's existing agreement, which obviously the UK was part of the EU's negotiation team at the time, and goes further. And it locks in all of those gains and goes significantly further. And I think 98% of UK goods currently going into Japan will remain tariff-free when our new comprehensive when our new agreement comes into effect on the 1st of January. I mean, three areas in particular where we've been able to go further than the one is on data and digital. We have removed requirements for data localization, which is something that is very important in Brussels. But I think from a UK context, we want to see tech innovation. And I think removing those requirements enables our tech providers to innovate more and to do more cross-border digital trade with Japan in particular. The second area is on financial services. Again, very, very important for the Scottish economy. We've gone further than the EU's existing agreement on financial services to make sure that it's easier for UK businesses to get a license to operate in Japan. And that will be of great benefit, I think, to Scottish financial services providers. We've also got better rules of origin within the deal. And then the final area, which is the area that you mentioned, Mr. Lockhart, on geographic indicators. The EU-Japan deal only had 7 UK geographic indicators. We have here the potential for 70 geographic indicators, which includes a lot of Scottish produce, Scottish beef, Scottish lamb, Arbroath smokies, and I think Stornoway black pudding, which Angus MacNeil, the chair of the International Trade Committee here in London, was particularly pleased to hear about, that is also potential for a geographic indicator being sold into Japan, which I think will really increase the recognition from consumers in Japan of high quality UK produce, and a big part of that will be produce from Scotland. So I think, yes, it is a very good example of how we can go further than the EU. That's the first area. The second area, that the UK is able to do its own trade agreements. You know, we are, after all, the world's 5th largest economy, and the ability to do independent trade agreements, I think, is one of the biggest opportunities facing the United Kingdom and all its nations going forward from here.
Thank you very much for that response, Minister. It does sound like there are genuine, significant opportunities to explore under the EPA with Japan, and I know that the Consul General of Japan was very excited about those opportunities. I'd like to turn now to future FTAs to be entered into after the transition period, because some concerns have been raised about the potential for the UK government to lower standards as part of the negotiations to secure future agreements. However, in many areas, regulatory standards in the UK already go beyond EU standards, for example, in health and safety, maternity, paternity leave and flexible working, to name but a few. Would the Minister be able to expand on the UK government's strategic priorities when negotiating and entering future free trade agreements, and indicate whether maintaining world-leading regulatory standards will be central to the UK government's approach to these future agreements?
Well, thank you, Mr. Lockhart. And the answer is clearly yes to that. We have been absolutely clear, both in our, first of all, in our election manifesto last December, the importance of maintaining and not compromising on the UK's excellent standards, explicitly in areas of animal welfare, the environment and food safety, that there'll be no compromise on those standards with any of our trade partners going forward. That is very, very important to us, and I think very important to consumers right the way across the United Kingdom. So those standards will remain very high. Second thing I would say is that nothing in any trade agreement would force the UK to change its own domestic or import standards. Those are entirely a matter for the UK government and also for devolved administrations to set those standards. And nothing in a trade agreement would prevent ourselves setting our own and keeping our own high domestic standards. And I'm absolutely confident on that front, and the UK government is absolutely committed to keeping those standards.
Thank you very much for that response, Minister. That's all I had. Thank you.
Thank you.
Thank you, Dean. Patrick Harvey, please.
Thank you, Convener, and good morning. You're clearly satisfied, Minister, at your own engagement with the Scottish Government. You believe that you've got an approach there that's that meets the expectation, or that's agreeable. But passing legislation like this doesn't require us to agree that there's a good intention. Passing legislation like this is about setting the rules by which not only you, but the UK government and any successor ministers that you might have will operate. So this could have been an opportunity to set the new approach, set a modern democratic approach to how these matters are handled, not just in relation to trade agreements with the limited range of countries under current consideration, but for the future as well. You could have introduced a bill which, for example, required UK ministers to negotiate within the UK prior to the establishment of their trade objectives, allowing civil society to contribute to comment on draft negotiating objectives, requiring a negotiating mandate for a trade agreement to be signed off in joint ministerial committee, involving genuine input and dialogue and agreement by negotiation at an intergovernmental level within the UK. You could have had a bill which required parliamentary scrutiny of draft negotiating texts, excessive negotiating texts, as indeed the European Parliament has the opportunity to scrutinise similar texts when the EU is negotiating agreements. And you could indeed have introduced a bill which requires multiple levels of parliamentary sign-off. And even if the devolved input in there is limited in scope to devolved matters, that would have established a proper, modern, democratic approach to the making of trade policy and trade agreements. This bill doesn't do any of that. Why not?
Yeah, well, thank you. Thank you for that question, Mr. Harvey. And let me try and deal with each part of it. First of all, I think in terms of the interaction we've had with the Scottish Government in relation to the legislation, I put it in my opening statement, but I would again emphasise that we've listened to the Scottish Government and the other devolved administrations in key areas. The amendment we made in relation to the restriction on the devolved minister's use of powers in the bill. That is a really, really important change. We have listened on that and made that change. And secondly, the restriction in the trade bill relating to Section 12 of the EU Withdrawal Act. We've listened to that concern and we've removed that restriction from the Trade Bill 2020. So I think if there's any sort of suggestion that the legislation we haven't interacted well with the devolved administrations, I'm telling you that those changes that we've made in the Trade Bill have come as a direct result of representation from the Scottish Government and other devolved administrations. I think, secondly, in terms of your point that we could have introduced lots of things into this bill, and that's not an unreasonable point of view, but our objective was continuity for this bill. That has been the most important thing, to secure continuity. The answer I gave earlier to Mr. Fraser about the importance of the aspects of this bill in relation to continuity. Those EU trade agreements, the WTO government procurement agreement, the ability to defend UK and Scottish producers from unfair trade practices in relation to dumping and so on. That's a really important aspect of our trade continuity, which is currently an EU competence. So our objective with this bill, and that remains the case, it was from the beginning and remains the case today, that this is principally about trade continuity. And now I think your third area, in terms of parliamentary scrutiny, look, we are confident that our offer on parliamentary scrutiny stands up well. It stands up well in terms of our sort of comparator countries. I think in terms of other countries that have a similar constitutional setup to ourselves, like, for example, Canada, Australia, New Zealand, we are confident that our offer on parliamentary scrutiny is at least as good as any of those three other democracies, which are most analogous to the UK system of parliamentary democracy. And in terms of what we actually do, it'd be worth having a look at the whole process that we follow in the UK Parliament for each of these proposed negotiations. We publish, first of all, a scoping assessment, an impact assessment of what we think the impact of the trade deal might be, including the overall impact of the economy. And that's quite an interesting exercise, because obviously that's a trade deal that we haven't even started negotiating at that point. But it shows what is the scope for doing a trade deal, for example, with Australia. What would be the opportunities, what would be the challenges, etc. We have so far had an oral statement from the Secretary of State to the House of Commons, repeated and published at the end of each negotiating round, a written ministerial statement as to how that negotiation round was proceeding. There's frequent interactions with the International Trade Committee throughout the whole process. And then for Japan and the other agreements, we will be publishing a comprehensive impact assessment, again to be scrutinised by Parliament. And then Parliament has the opportunity, through the Constitutional Reform and Governance Act, to have a vote on the deal, or at least to give it further scrutiny. So we are confident that our overall offer on parliamentary scrutiny is a strong one, and is at least as good as our, if you like, our comparator systems in that space.
Can I just have one more attempt to explore this? I suspect we're not going to agree, but let me just suggest to you that if continuity is your objective, one of the things that we are not going to have continuity in terms of is the democratic accountability of power compared with the way the EU itself makes trade agreements. Most famously, for example, the Transatlantic Trade and Investment Partnership raised very serious concerns. People across many European countries, including Scotland and the rest of the UK, campaigned against it, regarded it as harmful. Civil society, NGOs, trade unions and others campaigned and held power accountable and prevented the governments of the EU from doing something that they regarded as harmful. Under this bill, we are not going to have continuity of democratic accountability of power to make trade policy or make trade agreements.
Well, Thank you. I'm not sure I caught the end of that question, but I think in terms of continuity, look, there's a complete continuity here with the system that the UK has for the approval of international treaties, which is the Constitutional Reform and Governance Act 2010. But I'm saying on top of that, we've also added in a lot of additional layers of scrutiny with the involvement of the International Trade Committee, the publication of these documents throughout, which goes way beyond the continuity position. If it was pure continuity, then I could just say to you, look, this is the Constitutional Reform and Governance Act 2010 are still in operation today, and that's been the case the last 10 years. But what we have done is we've gone significantly further through our interaction with Parliament, through our publication, through our transparency, through the involvement of the International Trade Committee, and so on. So I'm confident that we go much further than continuity in this case in terms of our offer on parliamentary scrutiny.
Can you point to any example where the legislation you're proposing requires agreement in the Joint Ministerial Committee, for example, in relation to trade matters that will impact on devolved competence? Is that
well, if anything were to happen, like, for example, I mean, as it happens, the new Japan deal doesn't need a change in primary legislation to make it effective. But if it did, then that primary legislation would have to go through the relevant legislatures in the United Kingdom. So that would be an example in which parliaments would have a very clear say in any resulting legislation. As it happens, the Japan deal, we don't believe does need primary legislation. But I think in answer to your question, we are confident that where Parliament previously had a role, particularly in any implementing legislation, any changes in legislation, that remains as much a case today as it did then.
Thank you, Convener.
Okay, thank you, Patrick. Alexander Burnett, please.
Thank you, Convener, and good morning, Minister. Now, despite those who would wish otherwise, it's been very reassuring to hear from you that countries like Japan still trust us and are keen to make deals. So can I just ask what other lessons you've learned from the Japan agreement, and is this a template for the remaining 20 or so agreements?
Yeah, well, I think that is a good question. And one thing I'd like to say is that actually quite a few of these agreements were opposed by a number of Scottish MPs when they went through Parliament. Actually, the SNP Westminster MPs didn't vote for any of these agreements, to the best of my knowledge. Against the Canada agreement, I think abstained on the Japan agreement. This is the EU's version on the Japan agreement and the Singapore agreement. So, when others might be complaining about continuity of trade agreements, it's worth remembering that for the SNP at least, these are trade agreements that they often opposed in the first place, seeking the continuity of. But a broader question about what does it show? It shows, A, the ability for the UK to roll over current EU trade agreements and make them still operable in a way that involves everybody and does not dilute or diminish our standards. B, it shows our ability to actually improve on those agreements. I mentioned the 3 or 4 key areas with the Japan agreement that we can improve on. And the third area, just that the UK is back on the world stage with its own independent trade policy, which has not been the case since the early 1970s. The ability to assign international trade agreements, to retain or retrieve our independent seat at the World Trade Organization. These are all incredibly important things for our trade policy going forward, and the UK's position, and all of the nations UK position in favour of free trade and in favour of free markets around the world. The UK is now once again a leading voice at the WTO and in other forums, making the case for free trade and the international system. So I think on a number of fronts, the Japan deal was really, really important for showing a direction of travel for UK independent trade policy.
Thank you.
Okay, thank you, Alexander. John Mason, please.
Well, maybe just to follow up on that point, thanks, Convener. Mr. Hans, would you accept then that the EU actually would have much more clout when negotiating with the United States than the UK will have?
Well, not necessarily, Mr. Mason, but I mean, I could throw that question back to you as to whether kind of Scotland would have more clout than the UK. What I would say is the UK has shown with the Japan deal our ability to actually get a better agreement and to go further. And that is, I think, a tribute to our very, very skillful negotiating team to be able to do that. I think in terms of the US, we've just finished the 4th round of our US talks. We've exchanged market access offers. That is in a good place. We're making very, very good progress. I mentioned earlier that Scotland is actually, according to our own scoping analysis, set to be the nation or region of the UK that benefits the most. So I think the whole of Scotland should look forward to that deal.
Can I ask you about the Japan agreement? I'm not an expert on these things, but you said there's legal scrubbing going on and it's been done in principle. So how long does that take? What's the timescale for fully finalising that agreement?
Yeah, well, I'm expecting it to be signed next month in October. So the agreement in principle is very rare that anything of any sort of big substance changes between the agreement in principle and the signing. But it does need further work on both sides. But I'm confident that that deal will be signed and in place for the 1st of January, which is the date that we need it on.
Okay, thanks very much. Now, on the question of implementing trade agreements, from what I understand, there are powers to implement via regulations for 5 years. And then that could be extended for a further 5 years, which is 10 years, which does seem quite a long time. Can you give us any comments about why it needs to be as long as that?
Yeah, thanks, Mr. Mason. I remember our interactions when you were at the UK Parliament 10 years ago, quite fondly. So, first of all, I think there's often a misunderstanding about the sunset clause, that it's somehow about, this is actually a misunderstanding from the UK Labour Party in the House of Commons. They thought it was all about the agreements themselves. So this is not about rolling over the agreements. So it's not about every 5 years we have another look at the, e.g. the UK CARIFORUM agreement, whether we roll it over. It's just the powers to make amendments to primary legislation to keep those agreements operable. And that's what it's all about. So it's a power which is limited in scope, and we think on balance the right way to do this is to have it in place for 5 years, and then with the agreement of both houses of Parliament here, and we will definitely consult, by the way, with the devolved administration. We're committed to do that if we are to roll over these powers for a further 5 years. But that sunset provision would be under the affirmative procedure in both houses of Parliament. In the UK House, in the UK Parliament, plus with the consultation of the devolved administrations. And I think that's proportionate. I think not having those powers and not having the ability to keep those agreements operable, could be quite damaging to our businesses and consumers. And I think that is a proportional power to be able to roll that over every 5 years.
Okay, thanks so much. I appreciate you remembering me from being there 10 years ago. I got promoted after that. So my final point would be that the bill sets up the Trades Remedies Authority, and that's obviously a new body, I think, within the CMA. How would you envisage that new body, the Trades Remedy Authority, relating to the Scottish Parliament and the other devolved parliaments?
Yeah, well, thanks. It's not actually, John, it's not set up within CMA. It's an entirely different statutory body in place solely to look at measures taken in relation to subsidies, dumping, unfair trade practices. The idea is it carries out an investigation. The World Trade Organization regulates quite a lot of these, of how these things are done, and we would obviously follow those World Trade Organization rules. I think your question was how involvement of the devolved administrations. Well, on various fronts, when an investigation would be initiated, we would speak to devolved administrations where we think it's relevant. e.g. if producers of that particular sector are in any of the devolved administrations, we would certainly look to speak to the devolved administration. When the process starts and a call for evidence, that would also go to the 3 devolved administrations. If any of the 3 devolved administrations registers an interest in that particular investigation, e.g. there is a producer or maybe consumers in Scotland might be particularly impacted, not just producers would be impacted by that investigation, then can register an interest, and the Trade Remedies Authority would need to take evidence from the devolved administration and formulate that as part of its proposal. When it made its proposal, which of course under the Act the Secretary of State has the right to disagree with, the Secretary of State for International Trade, we will make sure that their proposal from the Trade Remedies Authority also gets sent at the same time as it gets sent to other UK government ministers to get sent to the devolved administration. So the proposal, let's say, although it's going to the Secretary of State for International Trade, it may have an impact on the UK Government Business Department or the Foreign Commonwealth and Development Office in terms of international relations. At that same time, we will send that proposal to the devolved administration once it's reached our Secretary of State. So I think in all stages of that process of a trade remedy investigation, the devolved administrations will be very heavily involved.
Yeah, thanks for that. I mean, I take your point that on an individual investigation, there could well be a relationship. I suppose I'm just thinking, would there be a Scottish representative on the TRA? Would there be an annual report? And I'm asking that because from experience, we've had a mixed experience with some of these UK bodies. I mean, for example, the OBR, we've had a very good relationship with. But when you take HMRC, I think to start off with, it was a bit tricky because they felt they didn't answer to the Scottish Parliament. But over time, that has improved as well. So can you reassure us that there would be some kind of good relationship between the TRA and the Scottish Parliament?
Yeah, well, thanks, John. I think that answer is the Trade Remedies Authority is set up in shadow form at the moment. It's based in Reading. And I believe, and I'll check in with my ministerial colleague, Minister Jayawardena, who looks after the Trade Remedies Authority, but I'm led to believe that the relationship is already there, has already been set up between the TRA and the Scottish Government. We sought devolved administration's views on appointment of and recruitment of non-executive members of the Trade Remedies Authority. But overall, what we haven't done is to have specific representatives from the devolved administration on the board. And let me try and explain why. It is not a representative body. The board is there to advise on international trade issues. And of course, some of those issues can have an impact, I totally agree, on a specific nation or a region of the UK more than another. But the idea of the board is that none of them are appointed, none of them represent. It's not a representative body. None of them represent any of the devolved administrations. And we've said the same in terms of broader producer interests or the trade unions, that this is not a body for interests, if you like. It is a body of experts when it comes to international trade and trade remedies and the action that might be taken. And we've been very clear on that. But nonetheless, I would expect the Trade Remedies Authority to have a very good relationship with the Scottish Government, I hope with the Scottish Parliament, and also with Scottish businesses and Scottish consumers.
Thanks very much.
Thank you, John. Can I just ask one final question of the Minister? Minister, in my opening questions to you, very helpfully said that you would have another look at how the Scottish Parliament might get more involved and devolved in scrutiny over new parts of rolled over agreements in devolved areas. I just wonder, in terms of the Trade Remedy Authority, is this not another area that could be re-looked at in terms of how it might be more accountable to the Scottish Parliament, not the ministers, but perhaps accountable is the wrong word. More effective scrutiny of the Trade Remedy Authority could be undertaken by the Scottish Parliament in areas where it is involved in devolved matters. And it would be possible, for instance, for the trade remedies to a report before the Scottish Parliament when it's involved in that sort of activity. At least it would draw attention to the Scottish Parliament of that action ongoing and provide an opportunity for deeper scrutiny.
Well, I think it's a fair point, Kavina. One thing I would say is that the annual report of the Trade Remedies Authority is that to be deposited with the Scottish Government as well, and with the other devolved administrations. That would then give the opportunity for the Scottish Parliament to scrutinise the work of the TRA. I'm all in favour of your committee and the Scottish Parliament having a look at how the Trade Remedies Authority is working. But I think that is probably the best way to do it, is to deposit documents and have them available for scrutiny by yourselves through the Scottish Government. I think that is probably the best way procedurally for that to happen.
Okay, well, thank you very much for coming and giving us some evidence this morning. I'm very grateful to you, Minister. I now suspend for 5 minutes to allow our next witness to join us, and enjoy the rest of your day, Mr. Hans.
Thank you, Kavina. Thank you to all your committee as well.
dann sind leider seit 3 Jahren nicht. Ihr könnt Meinungen anbauen.
We now continue our taking evidence on the Trade Bill 2020 with Ivan McKee, who's the Minister for Trade, Investment and Innovation at the Scottish Government. Mr McKee is joined today by Scottish Government officials, Reuben Aitken, who's the Head of Trade Policy Division, and Francesca Morton, a solicitor. I welcome our witnesses to the meeting, and I would invite Minister McKee to make a short opening statement should he wish to do so.
Good morning, convener, and good morning, committee, and I hope you can hear me okay.
We can hear you fine, yep.
Well, thank you very much. So, as you said, I'll take the opportunity to make a brief opening statement and then stand ready to answer your questions. I'm pleased to be here today to discuss the Scottish Minister's recommendation that the Scottish Parliament consents to the UK Government's trade bill, where consent is required on limited aspects of the bill. The bill was introduced into the House of Commons on 19th March of this year and completed its second reading in the House of Lords on the 8th of September. The committee will recall that the trade bill was initially introduced in November 2017, but fell with the dissolution of the UK Parliament in autumn 2019. The bill before us today broadly corresponds in terms of scope and policy objectives to the Trade Bill 2017, but with a significant change to our greatest area of concern last time round. The Scottish Government's legislative consent memorandum lodged in December 2017 made it clear that the Government could not recommend that Parliament approve the bill as it was introduced. Our main concern at that time related to the constitutionally inappropriate constraints imposed on the Scottish Minister's powers to implement provisions in devolved areas. The provisions constraining devolved authorities' powers under clauses 1 and 2 have now been removed. The purpose of the Trade Bill is to enable the UK Government to provide continuity for businesses by continuing to benefit from trade agreements the EU had with third countries, to avoid a cliff edge for businesses competing internationally under the WTO's Government Procurement Agreement, and to be able to pursue trade remedies now that the UK has left the European Union. And before setting out our reasons for recommending consent, it is important to make clear that the Scottish Government does not support the UK Government's approach to trade policy, which so far has excluded any substantive and meaningful role for the devolved administrations. Irrespective of the extent to which UK trade policy engages and impacts on areas of devolved policy and competence, the Scottish Government has had no meaningful involvement in trade negotiations, nor has it had any input into the identification of priority partners for trade negotiations, and the UK Government's intended light touch approach to engagement with and parliamentary scrutiny of trade agreements is not one we support. The Scottish Government is concerned by the absence of a statutory commitment by UK ministers not to legislate in devolved areas without first consulting and ideally obtaining the consent of Scottish ministers. In addition, although not a measure for which legislative consent is required, the absence of devolved administration involvement in the Trade Remedies Authority is little to reflect a collective approach to the conduct and administration of trade investigations. The wider context here is that the UK Government has left the EU against the will of the people of Scotland. It has also decided in an extraordinarily reckless move to end the Brexit transition period in the midst of a global pandemic and deep economic recession. This will inevitably cause huge disruption. Unlike the UK Government, the Scottish Government is seeking to do all we can to minimise damage to business and jobs. That is why we are recommending consent to relevant clauses of this bill, which, contrary to what the title suggests, is in fact relatively narrow in scope and largely technical. In the main, it simply seeks to maintain current trade arrangements from which the UK has benefited by virtue of its previous membership of the EU. The provisions of the bill for which legislative consent of the Scottish Parliament is required will enable full implementation of rollover trade agreements which Scotland benefited from through EU membership, and will ensure against potential gaps in Scotland's ability to access current and future procurement markets. Withholding consent where it is required on technical aspects of the trade bill will not benefit Scottish businesses or consumers. It is in Scotland's interest to mitigate damage to existing trade relationships, and it is our view that recommending consent is the appropriate way forward, despite the fact that it's a situation we should never have been facing. We will, of course, push for a greater role in the development and definition of UK-wide trade policy and arrangements, from the formulation of mandates to the negotiation, finalisation and implementation of trade agreements, compliance with enforcement of obligations at domestic and international level. We want to ensure that these serve Scottish needs and interests, to drive and support sustainable, inclusive growth and maintain strong ties with the EU. However, we are under no illusions that the only way to truly support, protect Scotland's interests, and particularly given the UK Government's behaviour over the UK Internal Market Bill, is to become an independent country and a full member of the EU. We're also committed to publishing our trade vision for Scotland, which before the end of 2020 will set our vision for trade, the principles and values that will shape the trading relationship we want Scotland to have in the future. This vision will underpin how we take forward implementation of our 3 cornerstone international economy plans on exports, investment and capital. That will reflect the Scottish Government's aims of fair work, inclusive growth, supporting the well-being of people and communities, and of course making the transition to net zero, as well as including a set of indicators which future trade-related decisions, both import and export-related, can be tested against. Convener, now more than ever, as we begin to develop new policy and strategy to recover from the unprecedented and deeply damaging impacts of the coronavirus pandemic on our economy, it is important that we do all we can, both in the short term and long term, to protect Scottish interests, and it's that principle underpins the Scottish Government's approach to this bill. Thank you.
Thank you, Minister. Let me start with approach and tone, because the tone from the Scottish Government is somewhat different from what we heard in tone from the UK Minister earlier, who talked about, I hope I characterise this correctly, a process of positive engagement with the Scottish Government as far as this particular trade bill is concerned. But I just wonder, in that light, how would you as a Scottish Government Minister characterise these relationships as far as this bill is concerned?
The Minister has also said that we'll have engagement. We don't always see eye to eye. I think it's true to say that round about the issues that you're talking about, the level of meaningful engagement, then we don't see eye to eye, and we do have frank exchanges of views on our meetings. First of all, I have to say it's grateful to Minister Hands that we do have the engagement in terms of the discussion, but our concern is that that doesn't go far enough. It's one thing to have the wee chats, as Angela Constance characterised it, but there needs to be much deeper and meaningful engagement. We have produced our paper, which sets out the role we see for devolved administrations in terms of being involved in that process, from the choosing of who the partner should be, the setting up of the negotiation mandate, and in being involved through the 3-room process that Mr Russell has previously articulated in terms of our engagement in the negotiation and then implementation of those deals. We think that is good for Scotland and the devolved administrations. We think, frankly, it's good for the UK and good for the partners that the UK seeks to negotiate trade deals with. It's fair to say that the sharing of information has been partial, limited, and the level of engagement that we've had in that process is not what we would seek to have on behalf of Scotland.
Thank you, Minister. As you know, Minister, under this bill, rolled over trade agreements could differ from original EU agreements, but there's no scope within the bill for devolved governments or parliaments to scrutinise any new aspects of these agreed agreements in devolved areas. And you may have heard the exchange I also had earlier with the UK Minister in that regard. In its LCM, the Scottish Government calls for enhanced procedures for parliamentary scrutiny and engagement with devolved administrations. Could you tell me what kind of enhanced scrutiny and engagement you would wish to see included within the bill?
Well, the issue, of course, is that the UK Government hasn't put anything on the face of the bill that requires them to engage with us, put that on the face of the bill to engage with us in areas that are devolved, and that is clearly a concern. Now, they have given commitments that they wouldn't intend not to do that, but we are concerned that is not in the face of the bill. Clearly, modern trade deals cover much more than just than trade, impact on a whole range of areas, which of course include many devolved areas, as we know. And our ask would be that the UK Government has deeper scrutiny, both in terms of the UK Parliament process, and that's something that obviously has been discussed at length at Westminster, and also in terms of the engagement with the Scottish Government, as I've outlined, and the devolved administrations, devolved parliaments should also have scope to be able to input into that process and have scrutiny of those bills. Now, the problem, of course, is that if you take the Japan deal, for example, Minister Hans said that that's now going through legal scrubbing. We, as a devolved administration, haven't yet seen the text of that Japan deal. So in the current environment, we're not even in a position to comment on the detail of that because we haven't yet seen it. So that, for a start, being able to see what has been negotiated would be a good start for that scrutiny process. But of course, as I said, we would want to be involved in the whole process, right through from setting the negotiating mandates, through the negotiating process, and then the implementation of those deals.
Yeah, I hear what you say, Minister, in terms of the Scottish Government not having seen the Japan deal. You may not have seen any of the text. We don't even know as a Parliament what the cover looks like. So I just wonder, I did push Mr Hans on that. Is there scope for a discussion between the Scottish Parliament and the Scottish Government about how the Scottish Government could help enhance our ability in the Parliament to scrutinise where it can these various arrangements, trade agreements?
Absolutely, there's work going on a protocol between the Scottish Government and the Scottish Parliament on how that engagement could and should work across a broader range of areas, and absolutely would be very supportive and very encouraging and very keen that there is as much scrutiny within the Scottish Parliament and through the committee as possible on trade deals going forward.
Okay, I'm going to hand over now to Murdo Fraser. I should have said that was my final question. I do apologise. Murdo Fraser, please. You there, Murdo? Somebody let me know if we've got a problem here. Hold on a minute, Minister, we'll see what's going on. Okay, listen, I'm going to move on to the next person who would like to ask a question. We'll come back to Murdo if and when his technical issues, if they exist, comes back in. John Mason, please.
Thanks very much, Convener. And I think, Mr McKee, if you saw my earlier questions, I'll be on similar grounds. I mean, firstly, the whole issue about the previous bill compared to this bill, I mean, Greg Hans seemed to be very reassuring that all of our problems and concerns had been removed. But I did notice he said that the UK government will not normally use powers without consent, and that phraseology kind of worried me a little bit, because normally it can mean almost anything. I mean, does the government have concerns about that?
Oh yes, and I think that the view that we took was on balance. Giving consent was the right thing to do for a number of reasons, but one of the factors that weighed on our minds was the fact that wasn't consent wasn't included in devolved areas, wasn't included in the face of the bill. Now we have pushed and have gained commitments in writing from Minister Hans and on the floor of the Commons in this regard. But yeah, you're absolutely right. The word normally, we've spent many happy hours debating the meaning of the word normally in committee and beyond. And yes, of course, there are concerns there.
Thanks. And then my second point, this whole thing about implementing trade agreements and the timescales for that. Which again I asked him, and 5 years plus an extension of 5 years to 10 years does seem quite a long time. Again, what are your thoughts about that? Is that too long?
Well, we can understand that. First of all, to be clear, this is about rolling over of existing trade deals that the EU negotiated with third countries. So it's deals that are already in place, and a number of those are already in place. A number of the key ones are still to be done, and we'll see how those progress. But a number already are in place. So we would hope clearly that a lot of this happens very, very quickly, because it allows businesses not to be disrupted, further disruption as a consequence of leaving the EU. And all of this is caused, of course, by us leaving the EU. If that wasn't the case, we wouldn't be having this discussion at all. So the length of time, I think, is there to catch some of those deals, of the 40-odd deals that could fall into a situation where there is prolonged negotiation and discussion that happens. We can understand that some of that could take a lengthy period of time. We understand, obviously, that international trade deals can be complex, and that can be the situation. Of course, then it's about the provisions in the bill that allow the implementation of those aspects to be taken into domestic law across the UK and in the devolved areas. So I think we're not overly exercised about that, given the narrow scope of the bill, and we understand that there could be a situation where, for a small number of countries, there could be a lengthier process than we would like.
Yeah, well, I confess I'd be concerned if we didn't have these agreements in place within 5 years, but I take your point. And the final area I wanted to touch on, as I did with Mr. Hands, was this the Trade Remedies Authority. Now, that's a new body, and as I said to him, we as a committee, or we as committees within the Parliament, have a very mixed experience dealing with UK bodies. Some of them, I don't think, do regard the Scottish Parliament, but to be fair, some like the OBR have been very good. So what's your feeling on this? Should there be a Scottish representative on the Remedies Authority, even though he said it's not that kind of body? Or should they be required to report to the Parliament? What's your thinking around
that? The TRA, we have pushed and argued on every occasion, every meeting I've had with Greg Hands and his predecessors. He's the third Trade Minister I've engaged with in my time as a Scottish Trade Minister. We have made the point clearly that we believe that the Scottish Government should be able to have a say in a Scottish representative, or make input to that, a Scottish representative that is able to understand the depth and complexity of issues as they relate in the Scottish context, which in many ways, in many sectors, is different from across the rest of the UK. The UK government has taken a position that is not what they intend to do. We intend to obviously the engagement with the TRA. We hope will be productive and constructive, but frankly, it's far too early to see how that's going to roll out. So yeah, we are not as comfortable as we would be by the fact that there isn't a specific Scottish representative on there. We will obviously watch and engage with the process as the TRA is set up to understand what that looks like. In terms of Minister Hand's comments on we were involved in that process, I think that perhaps talks to some of the disconnect around about how we all see this process. I checked with officials when I heard him say that, and the reality is that the advert for recruitment of members of the TRA was shared with us. So we were in the process, in as much as we were able to circulate the advert within Scotland for people to come forward and apply for one of those positions. But that was the limit of the involvement in that sense.
Okay, I mean, I take your point. It's a new body. This is my very final point. But could you and the Scottish Government keep the committee updated, do you think, as we go forward with this, any other concerns or issues that arise with the TRA? Absolutely we shall.
As with all other aspects of the trade bill and the wider trade agenda.
Thanks very much, Convener.
Thank you, John. Murdo Fraser has rejoined us. Murdo had connection challenges. Murdo, over to you. Oh, I thought he was back on. We seem to have still had problems. In that case, I'm going to go on to Dean Lockhart.
Thank you very much, Convener, and good morning, Minister. As the Minister will know, the United States is the largest source of direct investment in Scotland after the rest of the UK, and is Scotland's single largest international export destination market. So, given the importance of trade and investment between Scotland and the United States, does the Minister agree that a free trade agreement with the US should be an important priority for both the UK and Scottish governments?
Yeah, the member is, Dean Lockhart's correct. The US is our single largest individual country in terms of exports and export potential, and I know he will have read in detail our export plan we published last year, where it was highlighted that it absolutely was the case. Of course, the EU as a whole is a much larger export market and opportunity than the US on its own. But I think the interesting point to recognise here is that the trade that we do with the US at the moment is in the absence of a free trade agreement with the US. So there is absolutely plenty of potential and scope for businesses to trade with the US. And in my visit to the US last year, just about this time last year, we continue to work very closely with businesses and Scottish businesses that are there to export, and we have a significant infrastructure through SDI across the US to support those export opportunities and investment opportunities. So the answer is that we are perfectly capable, as we've demonstrated, of having significant export success in the US and attracting investment from the US in the absence of an FTA. So the question then is, what value does an FTA add? So in terms of removing specific barriers to trade market access barriers, there potentially are some issues there that could be upside. You've got to remember a lot of the activity in the US in the areas we are particularly focused on around about services and regulation there is controlled at state level and not at federal level, which makes it difficult to access those. It's also very important to recognise, of course, that we are in a position with regards to tariffs on many Scottish products as a consequence of actions by the US, which is problematic for Scottish business. But I think the most important point about a US FTA, leaving aside clearly there's many issues that members would legitimately have concerns about, roundabout well-rehearsed issues around about chlorinated chicken access to NHS and so on and so forth. But one of from a trade perspective, one of the largest issues that exercises us is anything that the UK does with a US FTA that puts barriers in the way of ongoing trade with the EU. Now, data flows are one area there where we have free data flows with the EU. The US clearly has a very different regime in place for management of data. There is a risk, given the importance of services and financial services in particular, that there could be things put in place that would make that problematic, and other areas where something that the UK negotiates as part of a US FTA that could be problematic with regards to that ongoing trade, the most important trade with the EU.
Thanks very much, Minister, for that response. And I recognise, and I'm glad you also recognise, the importance of a potential free trade agreement with the US. I'd like to point out that the Programme for Government, published a few months ago, mentioned a potential US free trade agreement on page 125, and said that these proposals would force Scotland to accept lower food safety, animal health and environmental standards, which would effectively be imposed by a UK government in pursuit of a US trade deal. Now, Minister, I would like to get ask what empirical evidence you have for this statement, because as we heard with the exchange with Greg Hands, in many areas regulatory standards in the UK already go beyond EU standards in areas of health and safety, maternity, paternity leave and flexible working, to name but a few. And we saw with the Japanese free trade agreement that there was absolutely no prospect of lowering trade standards or any other standards to secure that agreement. So looking at page 125 of the Programme for Government, I would like to get an explanation of what the factual background for that statement is in relation to a US free trade agreement.
I think that the key word there is agreement, and the whole point of an FTA is that you have the discussion to move both sides forward in an environment where there's a deal done, and the deal by virtue involves give and take, and the concerns that we very clearly have, as articulated as Lockhart said, is that there are areas where we would have concerns that the US would be pushing for access and issues around about standards that would conflict with the very important requirements that we have within Scotland across devolved areas to protect those standards. Now, in terms of why do we think that, I mean, I've met with USTR in Washington when I was there last year. I've met with representatives of the US government and the embassy in London when I was down there last year. I've had other engagement with the US, and if you look at the signalling, the messaging from the US and the actions that have happened around about tariffs that I've mentioned earlier, the US's primary focus is around about agriculture, and they make that very clear. And when you get into that space, then you're into an area where standards clearly are different, and the US has also made it clear in its messaging that it has requirements that it would be able to export its agricultural products to the standards it has, and would see that as its primary negotiating objective. So when you take that in the round, you look at the communication from the US, that at all those levels, agriculture is most important, and they see standards as being any partner conforming to their standards and not vice versa. You can understand why we have concerns round about that, not least by virtue of the fact that the UK government has been very reluctant to share with us the negotiating mandates and the overall negotiating positions they're taking with the US that would allow us to have comfort that those issues have been taken on board as part of those negotiations. I mean, for example, the market access offers that the UK government has made to the US through the current FTA negotiations, those have been shared with the US, but not with us. So we don't know what is in those market access offers and what the UK government is putting on the table there.
Thanks. Just very quick follow-up, Minister. You recognise that the concerns you raise are hypothetical concerns, and you haven't really pointed to anything in the free trade discussions that might lower standards. And we heard from Greg Hands that the UK government's strategy is to maintain high standards. You recognise that in a negotiation process, the UK government has said time and again that it will not lower food or other standards in the UK as part of a US free trade agreement. So do you recognise that the concerns you have might be hypothetical?
Well, I think all concerns are hypothetical. That's why they're concerns, okay? But I think if you look at the evidence, that the amount of sharing of those negotiating positions and the trade-offs that the UK is willing to make with us at the level we need to see them at, has it happened? The signalling from the US, agriculture is our most important issue, and that they have a requirement for other countries to conform with those standards. That's all on the table. So you can see why we would have concerns. Now, clearly those concerns can be allayed by sharing of that information and more involvement of us in that process, but I think it's perfectly legitimate for us to have concerns given that landscape and those facts.
Thank you very much, Convener. That's all I had.
Thank you, Dean. I'm crossing my fingers and I'm going to Murdo. I hope his connection issues are now completely sorted. Murdo?
Thank you, Convener. Hopefully you can see and hear me, and I'm back, reconnected. Thank you. Good morning, Minister. I missed some of the previous exchanges, so my apologies in advance if I go over some ground that's already been gone over. But I wanted to go back to a comment that Greg Hands made in the earlier evidence session, and he said that in relation to the previous EU trade agreements, when they went through the House of Commons, including trade agreements with countries like Japan, SNP MPs at the time either abstained or voted against these trade agreements. And I'm wondering if you know if that is true, and if that is true, why do they take that stance?
So I'm not sure on specifics on that, but clearly, as any vote, as Murdo Fraser is hugely experienced in these areas, the devil is in the detail. So I think we would need to trawl back and look at what exactly the proposition was that was on the table at that point in time, and what the specific concerns were around about those. It's important to recognise, of course, that the deals we're talking about here are deals that were negotiated by virtue of Scotland and the UK being part of the EU, and all that's really happening is that the UK government is running to catch up to get us back in the position that we enjoyed as part of the EU's negotiating power globally. Clearly we're supportive of that, because the fact that we were members of the EU allowed us to benefit from those deals, and we would hope to minimise the already significant impact that Brexit will cause on Scotland.
Thank you for that. I mean, you'll appreciate that the reason I asked the question is that what you're telling us this morning is that you want to see these agreements rolled over, you view them as important, and you want to have more of a say. And I'm just interested that you maybe can see the irony that we're talking about agreements that your own colleagues in Westminster either abstained on or voted against. So if they're so important now, why weren't they important to support at the time they were entered into?
Well, I think, again, as I said before, you need to go back and look at the detail on that. No trade deal is perfect. There are aspects of things that you always want to be improved. But I think we're drawing the distinction between, and I was talking about those deals when they were negotiated originally. We need to go back and look and see the specifics on that. And I'm sure there will have been areas where we would have argued that there could have been more done to protect and promote Scottish interests in that context. But in terms of the position at the moment, with regard to the trade bill, clearly there are concerns. I've articulated those concerns. There are concerns in the devolved remit that we've articulated clearly, and there are concerns at a Westminster level in terms of parliamentary scrutiny and so on and so forth that we've also articulated, where this is by no means a perfect scenario. It's something that we have concerns about. It's something that we've raised these concerns, and in terms of the Scottish Government, as we've taken the position that in the round, considering all the other things that would flow from there not being consent, then we believe that on balance this is the marginal decision, as it makes sense to give consent to this bill at this time.
Okay, thank you. Perhaps, Minister, you might be able to write to the committee subsequently with an answer to that question. Can I maybe just ask one more question, Convener? We've heard it from Mr. Hands. We heard it previously. The trade policy is a reserved matter. We've also heard from a lot of your colleagues over a long time that you and the Scottish Government believe that the devolution settlement should be respected. So do you accept that the devolved administrations, including the Scottish Government, should not have a right of veto over UK trade policy or UK trade agreements?
Yeah, I mean, we're not asking for a right of veto. What we're asking for is that with regards to devolved areas, should be due process that takes us into account, and that is absolutely our position. I think it's a very legitimate position, given, as I said, that trade deals cover a wide range of aspects, as a member knows, covering beyond what traditional trade deals would have covered in the past. Modern trade deals cover a whole range of areas that impinge very, very much on the potential and devolved aspects. And that is why, in those devolved aspects, we think it's only right and proper that there's due process for the Scottish Government and Parliament, devolved administrations and parliaments to have their say in this process.
Okay, thank you, Convener.
Thank you, Murdo. Patrick Harvey, please.
Thank you, Convener. Good morning. Good afternoon, Minister. I have to say I find your position a bit bewildering, this bill. Even just thinking about the last answer you gave to Murdo Fraser about the modest asks you have in relation to a devolved role in respect of devolved competence. It seems to me that this position sits completely at odds with your recommendation that we should give consent to this bill. Even in relation to devolved competence, this bill does not address the concerns that the Scottish Government seems to be setting out. This bill could have, but fails to, establish an input for the devolved administrations or the devolved parliaments into the setting of negotiating mandates. It could have, but it fails to give devolved scrutiny or even UK scrutiny to negotiating texts, the various iterations of a trade agreement as it's being negotiated. It could have, but it fails to give the devolved parliaments the ability to say yay or nay to the devolved aspects of a trade agreement once it's been signed off by the UK government. It doesn't do any of these things. Why should we agree to it?
Well, it doesn't do lots of things, right, but that's not the purpose of the bill. The purpose of the bill is very clear and it is very narrow.
That's the problem.
Yeah, I mean, a million things, Patrick, that you and I could say were good things to have that we could load onto the bill. The purpose of the bill is very clear. It's to enable the deals that we benefited from with third countries as a member of the EU to continue to be able to benefit from those post the Brexit cliff edge. That is the primary purpose, and to allow the UK and Scotland to be part of the WTO's GPA and to be able to access those procurement opportunities. So that is the primary purpose of the bill. It's continuity. It's to allow for us not to fall off a cliff, another cliff, as part of to make the cliff slightly less impactful as we go through the Brexit process, by ensuring there's continuity around about those trade deals. Now, the discussion round about what else we could get in those trade deals, what other trade deals we could do, what other wider trade policy should and shouldn't encompass, etc., 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 is a much, much bigger issue. I'm sure there'd be much common ground we would have there, and something we could seek to engage on. But the purpose of the trade bill is focus very narrowly on those trade deals that we benefit from as being part of a member of the EU, and to ensure that no further damage is done through the Brexit process as a consequence of us not having the benefit of those EU trade deals going forward.
But you've just complained a few minutes ago that the Scottish Government still hasn't even seen the text of the agreement with Japan. You know, very clearly, this bill, even in relation to the narrow scope that it has about the range of countries that it will directly affect, notwithstanding any precedent that it sets for the future approach, and even in relation to purely the devolved competencies, this bill clearly, largely, significantly fails to achieve the role for devolved scrutiny and accountability that your own government is saying is necessary.
Well, you've got to remember, these are trade deals that are already in place. These aren't new trade deals. These are trade deals that was negotiated by the EU that we've had the benefit of, some for many years. So what is happening is that we're effectively preserving where we are. Now, we have concerns we've articulated round about that. There are lots of things we'd love to have in a broader trade bill, of course there are. But again, this is a very narrow focus. It's very technical in nature. It's about ensuring that we don't take a step back with regard to the benefits we currently enjoy as a member of the EU with those trade deals that the EU negotiated with other countries. So that is the scope of it. To not consent on that then opens up a whole range of other technical aspects that would have to be put in place through legislation to make sure that those deals were able to be continued to be benefited from in Scotland and likewise with the WTO GPA. So it's important to understand this in context. When I have a discussion about trade, we can talk about that all day, about all the great things we'd love to happen, and there will be opportunity to do that. But the LCM on the UK government's trade bill is very narrowly focused. It's about the technical aspects of ensuring we don't take a step back in terms of the current benefits we enjoy as a member of the EU with those third-party trade deals. It's no more than that. That's what it is. We've got concerns around about it, but as I said, on balance, to not consent to that runs the risk of us taking a step back.
It really does seem to me that your interpretation of this bill and its consequences, its potential consequences, your suggestion that it's nothing to see here, nothing will change, it's all just continuity, depends entirely, that assumption hangs entirely on the trust of the goodwill of a UK government which is already committed to breaking international law. in respect of its ideological agenda, which has already legislated in devolved areas without the consent, against the explicit refusal of consent of the Scottish Parliament, why on earth should we take them at their word?
Well, the trade bill is clearly focused and explicit round about rollover deals. That's what it says, that's what it is, that's what the legislation says, and that's what it's all about. It's about ensuring that the benefits that we have of membership of the EU, with those deals that have been negotiated on our behalf by the EU with third countries, continue to be able to be implemented. That is it, right? So, and the WTA part that we've spoken about. So I don't understand the question. The question is saying that we don't believe anything the UK government says, and we don't believe that what they've written in the legislation is what they're going to do, and we don't believe anything they tell us or whatever, then clearly we've got to proceed on the basis of what is written in the legislation. And what the legislation says is that this bill, we might like it to be different, but it is very explicitly clear. It says that it's a bill that enables those deals as they exist at the moment, as the EU negotiated those deals, for those deals to be rolled over, for us to continue to get the benefits of those deals. That's what it is. And on the basis of that, then we see that. We all agree it's good to be a member of the EU. We agree that the EU negotiating those deals on the behalf of all the 28 members. We may not agree on all the details, but by and large we're comfortable with that position, because that's the position we would be in were we to stay or seek re-accession to the EU. And all that's happening is that those trade deals continue to apply to the UK and Scotland post-Brexit.
Even though this bill does not give a devolved role, either parliamentary or governmental, that you're saying is necessary?
Well, as I said, this isn't ideal, but the question is, do we continue to benefit from those EU deals, or do we not do so? Then we have had, as we said, the primary concern we had round about restrictions on the power of Scottish ministers has been removed. We would like to have had on the face of the bill something around the devolved competencies, but we have had written and oral agreement on that, commitment to that on the floor of the House. So that's where we are. We don't. Patrick's laughing, but at the end of the day, we've got these deals in place. We're perfectly happy with those deals from a member of the EU. When we re-access to the EU as an independent country, we'll be again perfectly happy with those deals as they are. In an intervening period where we are not a member of the EU, we are supporting that those deals be rolled over, so they continue in their present form and we continue to benefit from those deals. That is it. To say there's plenty of other things we'd like trade to be about, but that's not what this bill is about.
Okay, can we move on, Patrick?
Thank you, Convener.
Alexander Burnett, please.
Thank you, Convener. Minister, now you must be very relieved to hear that countries like Japan still trust us, and you must also have the opportunity to be very excited that these trade agreements are progressing for the benefits of Scottish businesses, not least around the massive expansion of PGIs. But separately to that, leaving aside the rollover of these 40 EU-held agreements and leaving aside a deal with the EU itself, can I ask you, which 3 countries would you like to prioritise agreements with first?
Well, clearly, first I want to talk on the Japan side of things, because I think there's some points there that are worth picking up, and I know Greg Hans made reference to this in answer to some earlier questions. First of all, the point around about GIs. The reason we're in that situation where only a handful of GIs were in the EU-Japan deal was because, despite our exhortations to them to do differently, the UK didn't put forward GIs to the EU to be included in that deal. So that was completely a failure of the UK government to deliver on behalf of Scotland. And the other thing that Greg Hans talked about round about the Japan deal was in terms of financial services. So I'll read what I've got here in terms of that. The deal, so this is the UK-Japan deal, the deal creates an annual dialogue between HM Treasury, UK financial regulators and Japanese FCA that will explore ways to further reduce regulatory friction. So once a year, they're going to sit down and have a chat about what they might be able to do to reduce friction. That is the extent of the tremendous benefits that allegedly are in this UK-Japan deal for Scotland's financial services. So in terms of the answer to the question, the issue round about trade deals is the answer is the EU and the EU. That is where our biggest market is by far, and it's where we see, if you look at the Trading Nation or export plan we produced last year, 12 of those top 15 countries are in Europe. And if you add in the 40-odd countries that the EU has existing trade deals with already, that we are scrambling to get in place and replicate, then clearly our future is as a member of the EU and benefiting from the negotiating power, the approach and the deals that they are able to deliver on our behalf.
Thank you.
You complete that, Alexander. If that's the case, I'll go to Angela Constance. Thanks.
Thanks very much, Convener. Can I ask the Minister how important is trust, reputation and being prepared always to uphold international law? How important are these touchstone issues in establishing future economic and trading relationships, particularly with the EU? And the Minister may also have heard some of the evidence that committee heard last week about some of the concerns being raised in the